Good morning, good morning, good morning. Just check in to see if we are here. It's supposed to start at, now, but it is not on here yet. I think they are just doing the attorneys are doing their stuff today. As you can see, I'm still in my office / whatever, my empty closet. I'm just waking up, sort of, kind of. I haven't even done my face routine this morning. So but we're waiting for court to start. I hope everybody had a good evening. Nothing bad happened. We don't have any bad news. There is a trial going on in California that I wish was on TV, but it's not being televised. There's going to be a couple of trials like that are not going to be televised. Good morning, good morning, good morning. Welcome. It's early. It's early. It's early. I know. I get it. These trials, man. Some areas get started super early. This was supposed to start now. But we are here. Say hello if you're here. If you're an early bird. I am not an early bird. I'm not a morning person. And just FYI, know that I do other videos. I have tons and tons and tons of other videos on my channel that are not just live streams. So if you feel froggy and you want to check out other videos, I do videos on many, many other crimes, criminals, stuff like that. So check it out. I have an entire series on Samantha Wall, where we are advocating for Michael Jackson Bolanos. I have done not a series, but I've done videos on Betty Broderick. I've done videos on Fabio, who was tragically taken out of this world by his horrible wife and her lover. And I mean, I've done many videos, so you guys could go to my channel and check out all the videos I've done on other tragic events. The Idaho 4. So again, there's tons of videos on my channel. So I don't just do live streams. But this, again, we're still waiting for them to get into the courtroom. So I'm putting an ice pack on my face because my face feels very bloated today. I'm very tired. There is the trial that I wish was being televised. There's two trials that I wish were being televised. One is in California. It is the Liette trial. I'm trying to think. It's the trial where the husband, there's no body yet. There's no body found. Let me look up the details of it because I hate talking about stuff I don't know all the details of. I'm not even spelling their name right. Chula Vista. It's happening in Chula Vista. So Larry Millette. Um, 5 years this has been waiting to happen. It's this trial, but they don't even have. Hi, Gwen. How are you? So my face is really puffy today, so I'm doing my ice pack right now. So the Larry Millette trial, that's the one that I wish we could be watching. It's not being televised. It's in California. That happened 5 years ago. They don't have a body, so she disappeared out of her home in 2021. Maya Millette. She wanted to leave her husband. She's a California mother. She was looking into a divorce. Apparently her husband found out about it, and then she disappeared, and they've never found her. Apparently this grew national attention. Then I have not heard of it until recently. Z was talking about it on her channel the other night. This happened in Chula Vista. They both worked for the Navy. Apparently he faces murder charges, but they've not found her body. So I don't know what evidence they have or what they're showing, other than the fact that she's missing. She's gone. So I don't know what evidence they're showing, but they're charging him with murder, but she has been gone. So they say that he was controlling. He was angry that his wife was having an affair with a co-worker, and was desperate to keep her from divorcing him. So he also spent thousands of dollars online to hire spellcasters to put magic on her to try to keep her from leaving him. And that after her disappearance, he stopped putting these spells on her suddenly. So he was hexing his wife. It's crazy. So it also states that the day after she was last known to be alive was when his cell phone remained turned off for 12 hours and went to an unknown location in the family's SUV. So it looks very, very suspicious for him. So for all these years of her disappearance, he's asserted that she voluntarily left and is still alive. So he's maintained his innocence this entire time. They have asserted that another person may be responsible for her death, which, if she's just disappeared, how is she dead? How is the defense saying that she's dead? So the trial is happening right now. Apparently it got super duper heated yesterday in court. The father of Maya was on the stand, and he got very, very, very aggressive with Larry in the courtroom, and the judge had to stop the proceedings and recess for the day. So it was pretty bad. But he also, I think, had made some statements that that no one would ever find her if she tried to leave him, that she would never leave him, and no one would ever find her. So I wish I could see what details or what kind of evidence they have, other than the fact that he turned his phone off for 12 hours. And I mean, where was he? And she disappeared. Like, she was last seen or last known to be around, and then his phone was turned off for 12 hours. So and then she was no more. And then I'd like to know how he acted after, what did he do? Did he try to help find her? Was he concerned? Was it another Scott Peterson type of situation? I mean, what was it? So, uh, then we have the Carmelo Anthony trial coming up here in Texas, June 1st. I really wish that was being televised, but it is not because it is a highly, highly, highly racial trial here in Texas. It turned into a racial trial when it didn't have to. Um, it, it's really sad. Austin Metcalf and Carmelo Anthony. Uh, Austin Metcalf was killed in an unfortunate situation. Um, Obviously, it was two teenagers at a track meet. I don't know. Apparently, Carmelo Anthony was at this track meet. I don't know if he was supposed to be there, not supposed to be there. It really doesn't matter. He was at the track meet. Uh, Austin Metcalf and his brother, that Carmelo Anthony was under their tent. It was raining, whatever, whatever. Apparently, Carmelo Anthony wasn't part of that school that he was under their tent. He was asked to leave. I guess Carmelo Anthony made a comment like, make me. Austin Metcalf and his brother were like, you have to leave. I don't know what caused this whole argument to happen. Either way, Carmelo Anthony pulled out a knife and he stabbed Austin Metcalf in the chest, which killed him. And Austin Metcalf died in his brother's twin brother's arms. They looked exactly alike. Uh, and Carmelo Anthony ran, and then when the police found him, he said, "It was me. I did it. It was self-defense." Um, I don't know, but why it's turned into such a racial issue is because Carmelo Anthony is black, Austin Metcalf is white, and they're trying to make it sound like Austin Metcalf tried to beat up a black guy. I don't know. It's just the most asinine thing in the whole wide world. Uh, and they're trying to make it sound like, Carmelo Anthony was at a all white track meet, and I don't know. It's so dumb. It doesn't have to be about a black white thing. It's just, look, man, you pulled out a knife in a situation that didn't have to be like that. It was basically two teenagers. You know, it didn't have to be a knife. Why did you have to pull out a knife? It's just dumb. So they're not televising it because it is highly, highly, highly volatile here in Texas over this whole situation. And there are a lot of people. Both sides of families have been doxxed. And there's a huge, huge, huge situation where obviously Carmelo Anthony's family has a huge, huge um, support system. And everybody's forgotten that a child died. I think it's really sad. I think it's really sad for both families. I mean, your son made a really stupid decision, pulling a knife out. The other two guys made like, why are you telling another kid? I don't know. I don't even think they were rival schools or anything. So, hi, Mark. How are you? So yeah, everything, it didn't have to turn into this seriousness of a matter, but they're also trying to excuse Carmelo Anthony because of that. And it just really, 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 I don't know. I'm just, so it just makes, okay, here we go. We got court. So, oh, hang on. Let me put us on the screen. Please approach. So I know they got a lot of questions today. I know that the lawyers are going to ask like why the jury was discussing. Who is this? Yeah, I hope everybody has good news today. Sorry, I have not done my skin routine. My face feels bloated. I'm super tired. So this is what y'all got. Sorry. The lawyers are concerned that the jury is talking amongst themselves about the whole objections and not understanding them. So we're going to be doing some this morning, taking care of some stuff. The attorney, I wonder who that was that went up to it. And y'all don't forget that I have other videos. I don't just live stream, obviously, because if I did, I would have like hundreds of people on here. Um, I used to have a bigger audience, trust me, but anyway, I have other videos on my channel, and I know some people don't know my background, but why I started doing true crime. I actually did have a background in criminal justice. I went to college for criminal justice. Go figure. I did go to Jacksonville State University in Alabama. That is where Joseph Scott Thomas is a teacher. He was not my teacher, but I did have some incredible teachers at JSU. And I ended up doing my career in loss prevention.
Good morning.
We have Defense Counsel President, Mr. Rogers and Mr. T. Good morning to you both. And we have the defendant, Ms.
I love true crime just like most women out there who have to fall asleep watching the people getting murdered. I mean, you know.
We had an objection motion to take up and 2 matters with jurors that we needed to address. And anything else that you all would like to address?
Keith Morrison's voice on Dateline relaxes me.
I think the court stated as the objection. I would ask that the efficient way to handle this is for it to be the Commonwealth's motion in limine to admit certain evidence. And there will be 3 things outside the presence of the jury that I'll seek to establish are admissible with one witness, Dr. Parrish, who is here. The 3 things that I'll seek to establish that are admissible are parts of the Newport News School District Handbook, parts of the Rich Neck Crisis Management Plan, and a video interview that Dr. Parrish did with the defendant. And so would court and counsel like to proceed on that matter first?
All right, and then Dr. Parrish, are we saying P as in Paul?
F-A-R-R-I-S-H. Yes,
all right, thank you, Mr. Jenkins. Okay, defense response.
Your Honor, of course, as the court has prevented me from making motions post
Can't do nothing.
previous days to do that. He's going to try to get these documents in. I'm going to obviously be objecting to them coming in. I really don't have a problem fleshing that out before we get before the jury.
Okay. And so I guess the defense response is all motions in limine and things of that matter were to be handled in a pretrial fashion. And we had several dates prior to the scheduling of this trial to deal with those matters. Why are we dealing with it now?
Because the defense is objecting, and I must lay a foundation for 2 exceptions to be met. And those exceptions would be the public documents exception and the business records exception. And those are evidentiary issues that without an objection, I would never have known to file a motion in limine on. So they had to tell me they were objecting to those business records.
Okay, and to the business records, and the other exception was?
The 2 exceptions that apply to the documents, I think both exceptions apply, are the public documents exception and the business records exception. And of course, I'll provide more detail on that if the court wants me to go ahead with the motion as a motion in limine.
And to the 3 things you would like to introduce into evidence, do the 2 exceptions apply equally to all 3?
No, as to the video, it is a statement of a party opponent. It is an interview of the defendant by the witness who I will have here on the stand. So the business records and public documents exceptions, I wouldn't seek to apply to the video, but I would seek to apply to the policies of Richmond.
All right, thank you. All right, to Mr. Rogers. What is your position if they're seeking to introduce it?
Your Honor, of course, I would have liked to have seen this motion in writing so that I could properly respond to each of those stated exceptions to the hearsay rule that they think applies to this, these documents, so that I would be able to have statutes and case law to defend against having those things admitted. Regarding Mrs. Parrish's testimony, her testimony is going to be her testimony. I believe the Commonwealth is going to have a problem authenticating the video, so she can testify as to what she saw and observed, but regarding the plaintiff video, that's we're going to be objecting on the authentication basis.
Okay, so let's break this down. 2, portions of the Newport News Public School Handbook, which Commonwealth is seeking to introduce. Let's not call this a motion limiting, but they're seeking to introduce. What's your position today?
Your Honor, my objection is going to be it's hearsay. It's going to be offered for the truth of the matter. So
Okay, so let's deal with that. So the hearsay and Commonwealth has already responded that they believe it falls into the exception of public documents and business records. What's your position?
my position is it does not. It's not a public record. It's a internal document that governs the policy of the Newport school system. And regarding a business record, if I could just look at it.
Yes, please. Okay, and let me pull out my.
Oh, the judge got some makeup on today. She got earrings. She got a cute little pop collar. Yesterday she was like, "It's Monday, y'all." I just got this headband on. Y'all lucky I'm here. Just like me.
This section in the rules of the Supreme Court.
Your Honor, I have several citations that relate to the admissibility of this, and I'll have to lay a foundation with Dr. Parrish to meet the requirements, but I'll be happy to.
Okay, I'm still at the Newport News Public School Handbook. That's what you're referring to?
Yes, Your Honor.
Okay, but give me just the public documents hearsay exception, statute and or rules number and business records.
Yes, Your Honor. Both the public documents and business records exceptions are codified under Virginia Supreme Court Rule 2803.
Yeah, Judge looking all good today. She's cute. Oh, I don't have to leave today. My husband's going to get the key Friday. So, because our landlord is, she's not getting done as fast as she thought. Oh, I could take this thing off my head now. Oh, I might look better with it on. Oh my Lord.
All right, and reading the.
Yeah, so he's going to get the key on Friday.
Section of Rule 2.
Oh God, I look like this.
Paragraph 8, public records and reports. In addition to categories of government records made admissible by statute, records, reports, statements, or data compilations in any form prepared by public offices or agencies setting forth A, the activities of the office or agency, or B, matters observed within the scope of the office or agency's duties as to which the source of the recorded information could testify, if called as a witness, generally excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel when offered against a criminal defendant.
So he's trying to enter in some evidence.
Business records, Ms. Jenkins, are you going under 6 in records of a regularly conducted activity?
Let me check the number.
If you're new here, say hello. I don't know if Kim is here, but I know she has court
Yes, Your
today,
Honor.
so she's probably like
And
stressing
read
out.
that. So
but we're
same
thinking about her.
section Rule 2:803, paragraph 6. Records of a regularly conducted activity. A record of acts, events, calculations, or conditions if, paragraph A. The record was made at or near the time of the acts, events, calculations, or conditions by, or from information transmitted by someone with knowledge. Paragraph B. The record was made and kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. Paragraph C. Making and keeping the record was a regular practice of that activity. Paragraph D. All these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 2:902, paragraph 6, or with a statute permitting certification. And paragraph E. Neither the source of information nor the method or circumstances of preparation indicate a lack of trustworthiness. Okay. All right, so again, we're back with parts of the new school handbook. Counsel seeking to introduce them, defense is objecting. Would the defense like to flesh out their objection?
Your Honor, I'll start with the records of a regularly conducted activity. I would say that those handbooks are definitely not those. This contemplates records that are.
So my question is, okay, they want to introduce the handbook, right? So are these people going to the handbook before they go do like?
Of that business. That's not what we have here. We have basically a policy and procedures book. A says the record was made at or near the time of the acts, events, calculations, or conditions.
So are you just referring to the handbook before you like take care of a at the moment situation?
Your Honor, these are one time.
And the reason why I ask this, the reason why I know this for a fact is because I have been in this very situation. I have been on the stand in court defending myself because I have been sued where I have had to go through the handbook.
All of those conditions have to be met.
And defend the fact that I stopped a shoplifter because we have to follow 5 steps in order to stop a shoplifter. And in those 5 steps, did I follow all 5 steps in order to stop this person? And this woman sued me over her son because I stopped her son. And they sued me. Sued my company, sued me. I won. We won. But I had to go through the handbook, everything that our handbook told us to do, every step. And I'm just curious as to, are you supposed to refer to your handbook while you're in the moment, while you're working?
One by one.
Okay. So with respect to the
weapon,
manual,
to go, we look in the
being
handbook.
a business record, I'll start with that one.
What does the handbook say?
I'll ask the court to rely on the case of Carmody v. F.W. Woolworth. Carmody is C-A-R-M-O-D-Y v. F.W. Woolworth, W-O-O-L-W-O-R-T-H company. It is 234 VA 198.
I mean, a handbook is
In
a
that case, an employer's employee manual was admitted under the business records exception to prove what a particular employee's duties were. And the court held that it was properly admitted under the business records exception. And so that case establishes a business records exception, and the Supreme Court has said that an employee manual, if kept in the regular course of that business, is admissible under that exception. I'll turn to the exception for public records as well. Actually, Judge, as to public records, give me just one moment.
Yes, sir.
So they're basically trying to get the manual in
As
because
to public
they
records
want to say
with
that the teachers
the
did the right thing. They took the
school
right thing.
handbook, the policy handbook, it is a report prepared by a public official, that being the school board, pursuant to the nature of their office. So it requires that they, by nature of their office, produce policies that relate to the schools under their direction. And given that, it's admissible under Williams v. Commonwealth, that's 213 VA 45, 1972, among 3 or 4 other cases about public documents. I will have a different argument on that related to the crisis management plan.
Anything further as to the Newport Public School Handbook?
Right, could I have just a moment to look at that Williams v. Commonwealth?
Yes, sir.
So in the prosecution opening arguments, they said that this principal was the only one who was allowed to search this child's backpack. She was the only one allowed to do it, or the security officer. And there was no security officer on the premises, which is not true, because even the teacher who was the victim, she stated that there was a security officer in the lunchroom and that this kid was looking at him all crazy like. So I don't understand. Anyway, none of this makes sense, because there were at least 3 or 4 teachers that were in contact with this wild 6-year-old that they believed had a weapon, and none of them removed the child or took the child down to the office, grabbed him by his ear and drug him down to the office and said, "You go talk to the principal." None of them did that. So they all just marched their, 2 of them marched their happy butts down to the office and said, "Hey, this kid might have," or whatever they said to the principal, and went back to recess.
Williams v. Commonwealth or Woolworth?
So I think this is, it's a terrible, terrible thing. It's awful that it happened. It's terrible that this child had the weapon, but that is his mama's fault. Come on. And that child has some anger issues. And that is also, a 6-year-old having that many anger issues is a problem.
I cited a couple of different cases. Are you the last? Williams v. Commonwealth is 213 VA 45.
And it takes 5 to 6 pounds of pressure to pull the trigger on that particular weapon. That little kid was about that life. That's crazy.
I'm not sure if the court has had a chance to pull up that case.
Yes, sir.
Okay. So it really does not support the Commonwealth's position. It is a case where the Commonwealth is attempting to get in information from the Central Criminal Records Exchange, and rule that it's referring to. It says it is generally recognized. It is a generally recognized rule that records and reports prepared by public officials pursuant to a duty imposed by statute or require who have the nature of their offices or admissible as proof of the facts there. And it goes on to say, but the mere fact that a record or report qualifies as a public document does not automatically overcome through. Say objection.
Mr. Rogers. Talking too fast for the man report.
I'm sorry. Unless the document relates facts or events within the personal knowledge and observation of the recording official to which he can testify should he call at trial. That's not what we have here. So that does not support the Commonwealth's position.
Thank you. So regarding the Newport News School Handbook.
I'm
Oh,
sorry.
yes, sir.
Mr. T is reminding me, the very first case, it's a civil case and it's not a criminal case, so it doesn't.
Thank you. So the hearsay exception of public records and report does apply to the Newport News Public School Handbook. And we can distinguish the cases as Williams refers to the CCRE, which is a criminal record database and history. Again, which is a different.
She's gonna let it in.
There are exceptions for public records compiled by law enforcement. And then again, defense has already distinguished the civil case. But this clearly falls within the statute as a permissible exception to hearsay. So the Newport News Public School Handbook comes in. Now, the Enrichment Crisis Management Book. Can you first explain to me what this is? I don't know. I need more understanding.
Yes, I can proffer that if the court wants. Dr. Farish is here and knows more than I do. But the crisis management plan is a document that the school board is directed to require individual schools to create and to update annually. This comes from Virginia Code 22.1-279.8D, where the school board is required to ensure that every school in the district produces a crisis management plan, reviews it annually no later than August 31st, and then the school board certifies in writing to the Virginia Center for School and Campus Safety that that annual review has been done each year. So it is a report, it is a plan required by statute. The contents of the plan generally is it outlines how faculty are to respond, and employees, faculty and employees, are to respond to all various manner of crises that could occur in a school building, not just violence, but just any sort of crisis, a fire, a natural disaster is covered. Many things are covered.
Are there scenarios that are factually close to the facts reported, in this case, covered in the crisis management book?
Specifically in the crisis management book, there are instructions both on what to do if a suspected weapon is in the building and what to do if an armed student may be in the building.
Okay.
And let me just add, Judge, exactly in both of these documents that I'm seeking to admit, my plan is to just admit the portions I believe are relevant via the testimony. And I wouldn't even seek to introduce the entire document. However, if the defense wishes for completeness to introduce the whole document, I would not object.
So does it say what the teachers are supposed to do?
And then you said you had additional argument on why this is admissible. If you'd like to go into that now so that they can get their cases together and be ready to respond.
Yes, Your Honor. For the crisis management plan, the strongest argument for its admissibility is the public documents exception. And that's because they are required to do it by statute. And that's one of the requirements of the public documents exception, is that either it be required by the nature of the duty or it be required by a statute. And here it is required by a statute. That statute is 22.1-279.8D, where the creation of the management plan and its annual updating is required by law. Given that, it qualifies as a public document, and we should be able to authenticate it by use of the custodian of records who is here. It is also a business record, I believe, Judge, for the same reasons that the manual is a business record, but I believe the stronger grounds for its admission is the public documents exception.
So does it say that teachers are just supposed to leave the kid in the classroom with a weapon? Is that what it says?
Yes, Ms. Deek?
Your Honor, regarding the handbook and this, the manual that was just referenced by the Commonwealth, the issue with these documents coming in is that it's going to be very dangerous and can confuse the jury. This is a criminal case. The handbook and the manual cannot set the criminal standard here. They're containing, as the Commonwealth has stated, there's a plan in place for what is supposed to happen in certain situations. I believe that the jury may confuse that with the criminal standard. This is a criminal case, it's not a civil case. The criminal case, the criminal standard is much higher than any, and it's not governed by the Newport News Public Schools handbooks or manuals. So while they may be relevant to the standard of care by an employee, they cannot be used in the analysis of criminal culpability. Additionally, the manual and the handbook presuppose supports that were not present at the Richneck Elementary School that day. In the manuals, it contemplates that there is a school resource officer in the building. That is not present here. So there are supports in those manuals and handbooks that are assumed that are not present in this case. So we object to the admission of both.
May I respond briefly, Judge?
Yes, sir.
The arguments of counsel just now are fair arguments for him to make as to the weight of this evidence, but those arguments don't go to admissibility. The admissibility is defined by the rule and the case law, and I understand counsel's position that there's little relevance is what it sounds like, but there's certainly enough relevance that it should be admitted, and that argument that we just heard could be made to the jury.
So, in respect to the Richneck Crisis Management.
I know this is boring, but this is like necessary because she's being charged criminally.
Hearsay exception of public records and reports. Now, I will say there,
Let me see how much time she could be looking at.
Doesn't make it admissible by statute, but it meets all other requirements of the public records and reports. And just for parties' edification, I do not find that these will qualify neither the public school handbook or crisis management manual under the records of a regularly conducted activity, as it has to be established that it was made at or near the time of the act or events or calculation. Annual manuals are different from a receipt, a purchase receipt. That's time stamped to say I bought this item then, which is a business record made at or near the time of events. That had not been established, so it would not come under that exception, but it does come under the other exception. All right, the third matter is the interview with Dr. Ferris.
40 years.
Interview. Now, I don't know what this is. I don't know what it's purporting.
Holy crap.
I don't know when it was reported. So if you could proffer to me some of that, and then we'll get into why you believe it's admissible and why they're objecting.
Yes, Your Honor. The video was recorded as part of an internal school investigation by Newport News Public Schools Human Resources. The interview was conducted over Zoom. On the recording of the Zoom, you can see that Dr. Nina Farish from Newport News Public Schools, the HR director,
40 years, y'all.
Of the defendant, Dr. Ebony Parker.
The mom
the video,
only got
I don't remember
4.
its total length, but in the video, the
40 years.
HR director is asking several open-ended questions about
What?
the incident at Richneck Elementary.
She's being
And
charged with
Dr.
8
Parker is
counts
answering
of felony
those
child
questions
neglect,
about-
1 for each bullet
And
in the gun. Are you
freaking
freaking kidding me?
In relation to the incident.
Are you freaking kidding me?
Was 2023.
Your Honor,
And
if
the
I could
mom
look that up,
only
I
got
think.
4 years, and she's already out. The mom is already out, y'all. What the? What? Oh, come on. Get out. Get out. This is ridiculous. I mean, get the heck out. This is a for show. This is ridiculous. Come on. 40 years? Oh. They need to take this on down the road, man. This is some garbage. I am disgusted. 40 years? The mom is out of prison. Oh, I am pissed. This is terrible. I mean, I'm all about getting justice, okay? I'm all about people taking responsibility, but this is some bull crap. She already has the civil case she has already lost. She already has been held liable $10 million.
If I may, what I can tell
money on
the
getting
court myself is
okay?
that the
But she didn't die.
schools
Did you
was-
die? She
The
didn't
HR
die.
director was assigned to do this report and began her investigation on January 9 of 2023. As to what day she interviewed the defendant, I don't know, but she is here, and I'll be happy to have her testify to that fact.
Okay, if we need to get to that part. And you believe this is admissible, you said under admission by a party opponent?
Yes, exactly as any criminal defendant's
I
statements
am
or confessions
appalled.
would be admissible. It's both a party opponent, and a statement against interest.
Okay, all right, and let me read those into the record. So again, under Rule 2:803, paragraph 0, admission by party
no.
opponent. A statement offered against a party that is A, the party's own statement in either an individual or representative capacity, or B, a statement of which the party has manifested adoption or belief in its truth, or C, a statement by a person authorized by the party to make a statement concerning the subject, or D, a statement by the party's agent or employee made during the term of the agency or employment concerning a matter within the scope of such agency or employment, or E, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. And give me the second one, Mr. Jenkins. What paragraph am I looking for?
Judge, I called it a statement against interest, but I think that really is encapsulated in the Virginia rules as an admission.
Okay, yes, the other one has to deal with property only.
Yes,
Okay, all right. Oh, okay, all right, defense.
Your Honor, regarding the statements that my client has made, there's really, I have no reason to object to any of her statements. Again, the problem that we're having is the video, indicating the video. If Ms. Parrish testifies, that's her statement that my client made. Can't object to that coming in. But as far as playing the video without proper authentication, then we
Okay, understood. And all of these are still subject to all of the other rules of evidence, especially regarding authentication. But we were just trying to get those out of the way. Okay, so then for the interview with Dr. Parrish, again, assuming it meets other admissibility requirements by law, it comes in. All right, anything else we need to take up other than the juror issues?
Anything.
Not to the problem.
Holy crap.
Your Honor, Mr. Teague has also advised me that we definitely have concerns regarding the actual interview, the coercive nature of the interview, that setting in whether my client felt like she had a right to not give those statements. Rather, we definitely believe that as far as the video is concerned, playing that before the jury would have a profound prejudicial impact on the jury, and we would ask that even though it's relevant, that the court exclude it based on the prejudicial nature of the statement.
Okay, and did you receive this in discovery?
I did.
Okay, why didn't we deal with that in the pre-trial motion?
I'll submit it.
Okay, you made your position for the record, but it is going to be allowed in.
It's too late now.
Two juror issues. I'm sorry, go ahead, Mr. Rogers.
You say it's going to be, her statement's going to be allowed in, but at this point,
Again, it still has to meet other rules of
okay.
admissibility. But in terms of you saying that she didn't have counsel, she didn't know that she didn't have to participate, those things could have been done prior to trial and were ordered to be done prior to trial, and they were not. So I'm not considering anything else regarding that. Now, we had one juror state she had a question, and we had one juror indicate he would like some clarity regarding objections to stricken evidence. My
Not stricken.
position was to have
Stricken.
the juror who had the question write it down with the juror number, and we read it out here on the record, and then I'll ask attorneys how they want us to respond to it. Do you all prefer to proceed in a different format?
That's fine for the Commonwealth. That's fine.
Okay, and again, they are not to be deliberating. So do you want to have just that one juror brought out here and write the question down so that it's not in front of the other jurors, or do you want the question asked in front of all of the jurors, or just pass us a sheet of paper?
I'll defer to the defense on how they want that.
Your Honor, we have no problem with her just writing it down, not being viewed by the other jury members, and then read by Your Honor.
Okay, so Sheriff's object, and I don't know her juror number, but it was the young lady who sat in the first row far left. If we could have her write down, I'm asking her to give me a sheet of paper with her juror number and to write down her question and just hold it out so that the other jurors can't see it, and you'll bring it out here and read it on the record. Thank you very much.
Okay, I have to, if y'all have not seen the mom, hang on. I have to show y'all the mom. So this is the mom of the 6-year-old. So she's not plastered all over the freaking news like this principal. The mom, Deja Taylor, pleaded guilty in August to state felony neglect in connection with the January shooting at Rich Nick Elementary School in Newport News, a misdemeanor charge of endangering a child by reckless storage of a firearm was dropped. This is Taylor's second prison sentence in connection with the shooting. In November, she was sentenced to 21 months in prison after pleading guilty to federal charges of using marijuana while in possession of a firearm and making a false statement about her drug use during the purchase of the firearm, both felonies. Police say the 6-year-old student brought a gun into his classroom and intentionally shot and wounded his teacher, Abby Zwarner, on January 6th. Zwarner sustained a gunshot wound through her hand and into her chest. Federal prosecutors said the firearm used in the shooting was purchased by Taylor in July of 2022. ATF agents never found a lockbox, a trigger lock, or a key for the gun. Deja Taylor faced up to 5 years behind bars on the child neglect charge. Prosecutors had recommended a 6-month sentence, which fell within state guidelines. The judge ultimately sentenced Taylor to 5 years with 3 years suspended. She will also serve 2 years of probation when she is released, which must include substance abuse treatment, parenting classes, and mental health treatment. The state sentence will be served consecutive to the federal 21-month sentence she is currently serving, the Newport News Commonwealth's Attorney General office said. She's already out. She got out last week. This is his mom. She's already out of prison. She got 20, she's out. And you know she got custody of the child. She's going to parenting classes. But she's not plastered all over TV like this teacher. Like, what the heck? She's going to get to move on with her life. And this child, and I'm sorry, but this little boy, he has to live with the fact that he shot somebody.
That they have to rely on their memory, and because the trial is still ongoing, that they have to rely on their memory and any evidence that the court
Getting
admits
milk.
during the course of the trial.
Went to go get some milk, Gwen.
Okay, and again, the court concurs, so that juror will be instructed, to rely on their recollection, but wait till the conclusion of all evidence. There will be more evidence presented, and not start deliberation until the case is given to them. So, yes, Mr.
On that point, Judge, I
Yay,
feel like it is
no
incumbent
smoking.
on us to voir dire the jury members, both based on her question and the gentleman's question as well.
Yes, so the gentleman absolutely, but you want to voir dire her as well regarding if she's spoken about this with other jurors?
Yes, only for that limited purpose, whether she's
Uh-oh.
spoken about it with other jurors. I
Jurors are
certainly don't want
talking.
To ask any questions about these 3 things she mentioned.
I'm going to call for a mistrial.
Defense position, if any.
I agree that should definitely needs to be brought here.
Okay, and so that we have a game plan for when she comes out here, we're just gonna keep it to, are these her questions alone? Has she discussed any of the case with other jurors?
Yes, and I would submit that the court can do the inquiry without us.
I just want to, okay.
And I would ask that the court inquire, has she observed any other jury members discussing anything pertinent to the trial?
Okay, those will be the 3
agree with
questions. All right, thank you. Okay, so Sheriff, if you can bring out just juror number 38, please. Yes, sir. While she comes out, again, I don't know who the gentleman was, his number yet, but absolutely we will voir dire him individually for the basis of his question.
Yeah, Gwen, I'm happy that you're not smoking. That's awesome. No smoking. Drink ginger bug instead.
Good morning, yes, you can have a seat in the jury box. Thank you, and good morning to you. Good morning. Okay. And I do want to remind you, of course, you're not being recorded, you're not on video, you can have a seat. Your face and information will not be displayed to the media. Okay, so first, I did receive the answer to your questions, and I have 2 responses. And my responses are required by law. One, you have to rely on your recollection of what the evidence is. And 2, evidence is still being presented to you. So please don't make decisions or deliberations until the case is given to you for deliberation, and that will be at the conclusion of all of the evidence. And I can't, you have to rely on your recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. That's why I'm not answering your specific questions. So I don't mean to be rude or disrespectful, but you have to rely on your recollection. So now, we had 1 question for you, or maybe 2 questions. Are these your questions alone, or have you discussed this with other jurors?
Yesterday, we had it, and it was like, and I guess I missed some of that information when it was given, because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed if those answers to some of that.
Okay, understood. And have you observed any of the jurors discussing the case? Because they are not supposed to discuss the case until it's given to them for deliberations.
No.
All right. Thank you, juror number 38. One moment, let me see if the attorneys have any follow-up.
I don't.
I think
Okay, all right, thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with evidence today. Sheriff, the gentleman in the back row far right, you know who it is? Oh, okay, yes, so bring him out. I don't know his number.
Well, no mistrial. The jurors aren't talking. They're just retarded.
Oh, good morning, sir. You're welcome to have a seat. Thank you very much. And if you can give me your juror number.
Juror 33.
Thank you, juror number 33. All right, and again, I do want to remind you, your face is not being filmed and your information will not be released to the press. Okay, yesterday you had a question, and so we would like to hear your question, and then we'll decide how to respond, and then we may have questions for you. So yes, sir, juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in a witness testimony or from what point in conversation we are to omit from?
Okay. And I'm now going to turn to the attorneys. My position is by law that we give the response of you have to rely on your recollections as best as you can. Just come up with a different response.
No, not on that issue, Judge.
Does the defense wish a different response? And I do understand we're going to ask some other questions about the we part. But Mr. Rogers, can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying,
Okay.
as it did before.
Wait, giving the same response or offering clarity? Giving the response that he has to reply, the jurors have to rely on their independent recollection.
That satisfies.
Okay. Ms. Teague?
Yes, Your Honor, I think my clarification that not only do they have to rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account should be just done just so, considered or handled just so. They cannot consider it.
Okay, thank you. Okay, so juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point, but what if I don't remember what was struck or not, and I got confused in the
Why are you supposed to
saying
take a
those
note?
rules? You can consider this, you cannot. Again, you have to rely upon your recollection as best you can. The
Somebody's facing up to 40 years.
And the Supreme Court law regarding that are that I don't want to, they frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to clarify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. Now, you use the word we several times. Why do you use the word we, and are you discussing that? Have other jurors expressed the same confusion?
The other jurors have not expressed that confusion to me. I posed that question to the other jurors and none have an answer.
Okay, And other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case?
No, ma'am.
Okay. And the reason I ask is because they're not to discuss the case, which is deliberate until it's formally given to you at conclusion of evidence. So there have been no discussions about the case.
No, ma'am.
Okay. All right. I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
We don't have another question.
Okay, Mr. Jacobs.
I don't have any questions.
Okay, thank you, juror number 38. You can retire to the room. We have one more thing to take up, and then we'll start the case.
Quick correction, Judge.
Oh, you have a question?
No, quick correction. Just now, we referred to him, the court referred to him as 38. He's
No, 33. Thank you. 33. Juror number 33. I'm sorry. Thank you. You can retire to the room, please.
So we've talked about this in past videos, but like if you have a jury of your peers, this is what 12 jurors are supposed to be, a jury of your peers.
Your Honor, can I just step out for a quick minute?
Yes, sir.
These people don't understand simple instruction. Okay? Simple instructions. They can take notes. They don't have to take notes, but they are allowed to take notes if they want to. But they're not taking notes. They're trying to rely on their memory. People, if you're sitting there and you can't keep up with all the objections going back and forth, you should probably take notes. This woman is looking at 40 years. And so also we've talked about a jury of your peers. She's a doctor. She's a very well-educated person. I'm just trying to figure out, like, what is a jury of your peers? If you were on trial for your life, who's a jury of your peers? Who's judging you? Who's in that box? Who did they pick? Is it a jury of your peers? Is there other doctors in there? Is there other like intelligent people? Clearly not, because they can't follow directions. I mean, I'm just curious. Like, what kind of people are in the box? That's why I don't know if I would trust 12 people or if I would trust a judge. Probably wouldn't trust a judge, though, because judges are corrupt. But 12 strangers whose brain level I just worry about. I just wonder. Because there's so many emotions, so many dumbness going on. I just don't have faith in that kind of. It worries me. Because then you have people asking stupid questions. I mean, I'm sorry. To me, if you're not taking notes, I just feel like you would have an entire notebook full of notes for every witness. Like, oh, that's a good point. Oh, you know what? Why didn't that teacher go to do something with that child? Why didn't this teacher do that? Take notes. Strike that answer. I just feel like it's not rocket surgery. It is, but it isn't. This teacher is facing 40 years. The mom got nothing. The mom is already out of prison. Mom's already out. She left a loaded weapon in arm's reach of a 6-year-old that he took to school and pointed at a teacher and shot her with, and she's out all free willy in it. And the principal who was sitting in her office is on trial now for each bullet that was in the gun, as if she loaded it herself. insane.
Number 33, anything in addition to his report, any comment on his responses?
Yeah, sure. Regarding juror number 33, I think what's most telling is what the juror stated while he was not being asked direct questions about whether they discussed the issue or discussed the case. Several times he used the word "we," indicating that there had been deliberating before discussion of the case between the jurors. He stated that he asked a question about the objections and what they're to consider and what they're not to consider. And nobody could give the answer to that question. That indicates that there was discussion about the issue that he raised with the court. Moreover, the issue or the questions raised by juror number, can't remember.
Was that the young lady?
Yeah.
38, she's 38.
38. Your Honor, frankly, I think those questions were improper and have, kind of aided the Commonwealth with knowing what is important to the jury in real time as the trial is going on, allowing them to potentially shape their ongoing examinations of their witnesses. And so, Your Honor, for that reason, we believe that we're making a motion for a mistrial.
And she's going to deny that.
Just a moment.
Yes, sir.
We knew they were going to ask for a mistrial. I mean, the jury is, this is telling. The jury got questions, and I think that's not fair. I don't think I've ever seen anything like this, where the jury is asking questions. I mean, they're not technically allowed to ask questions. Dude, you know you're wrong. You know this is wrong.
Judge, with respect to the issue with number 33, sort of announcing this question to the panel, I share the defense's concerns about that.
Yes.
It sounds to me like the question almost suggested to them that they should be confused about it and started to start them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked. Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. You wouldn't be allowed to do that, for example. However, and while I know number 38,
Dude, just say.
I feel like number 38 has, begun to form conclusions in her mind about the case as well.
Yes.
And given that,
I submit.
I think I have to agree with the defense.
I will recess to consider this. Again, we also have 2 alternates. So we could release jurors 33 and 38.
I know, they're all tainted.
Jurors. But I do understand your concern that, again,
I know.
juror 38 were her questions alone.
I
They
know.
were not shared or disseminated.
Yes, they
to
were
the other party.
in front of everybody
So if
yesterday.
there are concerns about juror 38's question, juror 38 could be released as an alternate, and we still have a constitutional jury panel. Juror 33 did ask his questions of the other jurors, and we're all grateful the other jurors didn't respond and followed the cautionary instructions that the court did give not to.
You better
deliberate
mistrial.
Until this case is given to you for deliberation. Now,
Hey,
let me
China.
add to this. The sheriff has indicated juror 33.
They gonna have to do a
The
mistrial.
gentleman does have a notepad back there that was not a notepad court issued, but we don't know what's in the notepad.
It don't matter.
Let's bring him back out again and see what's in the notepad. Well, hold on, Sheriff. Yes, Mr. T.
Just for the record, regarding juror number 33, his testimony, from what I recall, was not that they did not answer him. He's saying that they didn't have.
Oh, they said, yeah, you're right. They didn't know.
Right. So there's, to me, that indicates.
So let's follow up on that. Okay, we're not.
Girl, you better mistrial this thing. You know they wrong for that. Because the jury asked all these questions at the end of the day yesterday and in front of each other. So they already are going to find her guilty. They're already leaning toward finding her guilty.
Okay, and you can have a seat, juror number 33.
Thank you, ma'am.
Okay, two questions of clarification. I do understand you said you asked your questions of the other jurors, and if you could give me the detailed verbatim responses you received, whether it was they did not answer you or they said words, if you could give me the actual, your recollection of those conversations, and with how many jurors?
My recollection of the conversation was when I posed the question, our officer here, and he said he could not answer it, would present it to you.
And you posed the question to who? Oh, okay, gotcha, the sheriff, okay?
Yes.
And he said he could not answer
Could
it.
not answer those questions for the judge. And he stepped out. He said, I'm just curious about making sure that our information is accurate. Trying to remember verbatim the responses, but generally it was just I apologize, I did not try to log that in my memory.
China, she's facing
I don't
40
remember any
years
particular responses.
for this.
As much as that might be good to clarify, it'd be good to know. The conversation moved on, I believe, to traffic cameras.
This is some bull caca.
I believe that was the extent of the conversation. I'm sorry, I can't be more
So
specific.
your memory is fine, and, so did anybody, were there responses, or did they greet you with silence? Did you receive responses to the question?
The only responses I can recall to any extent,
And the mama out of prison.
the general assent, that clarification would be good to have.
Okay, and how was that general consent, that clarification would be good to have conveyed to you? Was it a physical gesture? Was it
I
a
would say
verbal?
verbal responses to the extent of something to the effect of, oh yeah, that would be pretty good.
Okay.
Yes.
And do you know how many would have shared that, if you can approximate?
Maybe 3 or 4 people.
Okay, and those are my questions for you, but again, as procedure, I'm going to.
Yeah,
turn to
she's
the
being
attorney
charged
if
with
they have
8
additional
felony
questions.
counts, China, and it is for each bullet that was in
You
the
just in
gun.
passing mentioned
40
conversation
years.
about traffic cameras.
Yes.
Is that right? Was it like, could you describe the nature of what that conversation was?
It's disgusting.
Trying to remember, because it was going between considering my question, sipping my coffee, and generally paying attention to traffic, so I apologize if this is not totally specific. We're trying very hard to not discuss the case in any capacity, so we're finding other topics of conversation. People were discussing times that have been clocked by traffic cameras.
Okay, so
and that type of thing.
sure. So it wasn't in relation to, is there traffic camera evidence in going to be
no,
shown in
not
this
at all,
case?
sir.
Okay.
No.
Oh, thank you. I don't have anything for
Okay, Mr. Rogers and Mr. Teague?
Yeah,
Okay, no additional question. Okay, and then juror number 33, it was mentioned to me that you had an extra notebook. Are you reporting any notes from the trial in that extra notebook?
The extra notebook was the initial notebook I brought in. I was unsure if notebooks would be provided to us. I left it here with the other one. I believe it just simply says jury notes and the date. And when I heard that we were not allowed to make other notes, the notebook was placed down on my feet and has not moved from that position.
Okay, wonderful. Thank you. And
You're
so
welcome.
again, let me, because I changed the topic, I'm going to turn to the attorneys and make sure they don't have any additional questions.
None from the Commonwealth.
Okay, thank you, juror number 33. And again, you were not in trouble, but we just have to make sure everything is perfect. And circuit court, that you can retire back to the jury.
Well, they
Thank you
asked
very much.
questions yesterday to clarify some stuff that were being asked of the witnesses. And it turns out that one of the jurors,
Anything
when
additional
she asked a
before I
question, one of the questions she
take
asked
recess to,
makes it look like
research and
they are
consider
already deciding
the mistrial motion made,
this case.
based upon.
And it's not in favor of the defendant. So the defense, of course, has asked for a mistrial.
My position remains the same. No,
And the prosecution
I
actually
understand what you're
agreed
saying, and just want to.
that there should be a
note
mistrial
that
because the jury is
juror
tainted.
seems to not remember, according to him, not remember exact conversations that went on regarding the issue.
And the jury is talking
So,
amongst
again, I'm gonna
themselves.
retire to deliberations. Just for human planning purposes, it'll probably be at least 15 minutes. So if people need to use the restroom or go to the car or something, please feel free to do so. I'll be honest, I'm inclined to deny the motion, even though both parties have made it. As the question for clarification, did you understand that? And the responses, I think will be harmless, but let me research it and consider it in detail.
Yeah, the judge ain't trying to
Let
mistrial.
me see, it's 9:54.
But she gonna get a retrial?
Try to check in at 10:15, and then, Madam Mayor will make sure jurors have, extra snacks and whatever they need, because they've been in that room a good hour and 15 minutes by that time. Okay, I will be in recess, thank you.
This is crazy. Okay, so the other juror came in. They both asked questions in front of the other jurors yesterday. Asking, one asked about objections. How are they supposed to consider those things that are stricken, blah, blah, blah. The other juror actually asked about considering answers. And the way she asked it was in a way that they were considering the defendant guilty. They were leaning in the prosecutor's light. And so the defense, of course, stood up and said, we want to call for a mistrial because the way these jurors are talking, and it sounds like they're talking amongst themselves, even though they said they weren't, but the way they asked these questions were we. And the prosecutor even stood up and said, we lay down, we surrender, we agree, we think this jury this is a mistrial. We're agreeing. But the judge is like, well, we have two alternate jurors, so let me think about it. But the alternate jurors are hearing the same thing that the regular jurors are hearing. So just because you have two alternates doesn't mean that they're not tainted too. They're hearing all of this stuff. I think she's setting herself up for, I know this trial is only supposed to last a couple of days, but she's setting herself up for another trial. Anyway, I cannot believe this woman is facing 40 years. 40 years. When all of those teachers got on that stand, and every single one of those teachers, especially when the defense attorney was like, so you believed that child had a gun. Well, I didn't know what kind of gun. I'm sorry, does it matter So if it was just if it was just a baby gun, as opposed to you would have done something about it, or you wouldn't have done anything. I mean, I'm trying to understand the rationale. So make it make sense. Make it make sense. So all of these teachers, they clearly did not, honest to goodness, believe that this 6-year-old, actually the only one who maybe kind of sort of thought that he had something was the one who searched his backpack. But none of them actually thought he was that much of a threat, because none of them took him to the office. They all let him go to recess. They all let him stay around. And they're going to blame the administrator who was in her office. Administrators and teachers are totally different. I mean, I'm sure y'all are aware. I mean, my friend is an administrator. She's a principal at a school. She's the principal at a school with 3,000 kids. I need y'all to put that in perspective. 3,000 kids. If a teacher came to her and said, "Hey, I think Joe Schmo in building 5 has something." Okay, she's in the principal's office. If you're the teacher and you think Joe Schmo has something, then why did you just bypass 5 buildings to come to the principal? So you see what I'm saying? Like, there are other steps you could have taken than go to the principal's office. You could have grabbed Joe Schmo. You could have gotten, I mean, there's just so many other things, and now they're blaming the principal. It just doesn't make sense. I mean, I can't wrap my head around it. And maybe they did tell her, I think little Johnny boy here has got some emotional issues. Maybe he's angry. Maybe he's whatever. Okay, but still, let's take Johnny boy to the office and have a sit down and talk to him. But nobody did any of those things. And also, the reading teacher said that little Johnny boy was acting out of character. She said he was actually pretty good. The only teacher, and I mean the only teacher, that didn't like Johnny boy was the one that he actually shot. That's the teacher that was afraid of him. That's the teacher that was like apparently terrified of the 6-year-old. So I don't know. And the only time that the teacher who searched his backpack saw any real bad behavior out of him was, of course, after she grabbed him after he did what he did, and he started cussing and screaming, and then he punched her in the face. So that's when we saw when she saw all the craziness out of little JT. But I hope this judge makes the right decision. I really do, because this woman will get a new trial, Ebony Parker. I wonder what the chat is saying about this, because I don't know what they're saying. Let's see. I don't know. The chat's not really saying they want her to. They're not saying that they want her to be guilty or not. Because usually the chat is like super mean. You know, they're always ready to hang somebody out to dry. Hmm. Yeah, I'm surprised that she's thinking about not calling a mistrial. I'm very surprised. And I'm shocked that this teacher is facing 40 years, or the principal. Really, really, really surprised. That's sad. It says that the mom they felt that she showed no remorse. And that she argued domestic abuse, substance abuse, and mental health. And those were the key issues that were mitigating factors and the system failing her. But they really do blame more of the school district, more of the principal than they do of the mom. It's really, really shocking. I mean, really, really shocking. So they don't hold the mom accountable because of her circumstances? What? So the teacher who was the victim, she sued the school district for $40 million. I mean, so the mom she's not in prison. She's free as a bird. And the school district was sued for 40 million. The principal was sued for 10 million. And now she's criminally on trial for 8 counts, felony counts. And the mom is just, the teacher holds the school and the principal more accountable than the mom. I just find that shocking. For a 6-year-old. Now for like teenagers, I think equal. I can see kind of equal, maybe. But a 6, I mean, like, what is, I mean, things are not like they used to be. Like, I remember growing up, I mean, we grew up where my grandparents grew up. They had a farm, and I mean, my pop, he had guns everywhere. It's just, it was different, but we knew better. I mean, you just can't. I don't know. It's just I can't. We just knew better. I don't know. Like, I can't explain it. I don't. It's just not like that now. But I mean, it's just different. And then I just think it's all how you're raised. Definitely how you're raised. I mean, we do not touch. We would never. I mean, we were more afraid of my pop than we were afraid, because there's no way. But I mean, but we also, it's just different. It's just totally different. Back then, we didn't have the social media. We didn't have video games. We didn't have, you couldn't you couldn't get yourself another life, you know, like you can. Yeah, the gentle parenting, yeah, we got our asses whooped. We got whatever our parents could reach, you know. Yeah, yeah, China. It's totally different now. Like, my pop, I could walk into my grandparents' house. There'd be a shotgun behind the door. My pop had a Colt 45 sitting right next to his recliner. I mean, there was guns everywhere. So I was raised around it. I mean, I didn't live there, but every time I went to my grandparents' house, it was a known thing. So, I mean, growing up, that's just something that, we saw. Yeah, right. That's how it is now, China. Like, kids today are graduating high school and can't read, you know. And that's why I'm saying, like, I look at these jury panels and I'm thinking, is this the people you want to be your peers, the jury of your peers? I don't know, because the questions that they asked yesterday, I'm like, damn, y'all should be taking some damn notes. This chick is looking at 40 years. And you don't know? You don't know? Like, hello? So, bitch, please, I need you to pay attention. So, but it's just different. Like, my son grew up, Seth grew up around, he had his, I'm not gonna lie, we bought him his first one when he was 12. But he didn't have it. It's not like he had it in his bedroom, in his closet, or, he didn't have it. But I mean, he got one. That was what he got for his, I don't know if it was his birthday or Christmas or what. Yes, we were those parents, but we lived in Alabama. He went hunting when he was a kid, but he didn't carry it around in his pocket or anything. But I mean, but but he was taught. He was properly taught out in the country, like all the kids that we live out in the country are. And he had it. He got to take it with him with his dad, and you know, but all of ours were locked up just like, you know, they're supposed to be. But I mean, it's like a rite of passage, though. It's just something that, I mean, I see this stuff that's happening with these kids today, and I'm just like, I'm kind of torn. I'm kind of torn because I do see kids that get that they're like, oh, look, people say stuff about them online. They're like, oh my God, I can't believe their parents bought them that. I don't see anything wrong with it. If they're good parents, if they're responsible parents. If they're not, you know, then obviously there's something wrong with that. But to just label the parents to be like, you know, I mean, obviously a 6-year-old shouldn't have one. I mean, I don't know why this woman had one available to her 6-year-old. And I don't know why they didn't charge the mom with 8 counts, felony counts, for every bullet that was in it. You know, that makes no sense. But I mean, I'm just saying, like, it just, in some cultures, I mean, in white trash Alabama culture, redneck culture, we have them. We get them. It's a rite of passage. It's what happened when you grow up to be a man. That's what you get. Okay. And you go hunting with your daddy. And I mean, hell, when I was a kid, that a freaking teenager would have one in the back of it was in the back of his pickup truck. It was right there. He had gun racks. I mean, that was just normal. I mean, it ain't normal now. I mean, you can't do that now. But I mean, she was like riding in the back of a pickup truck. It was just normal. But you can't trust them now. It's crazy. I don't know. It's just now everybody's like clutching their pearls and is like, oh my God. Yeah. I mean, why can't we have it like the good old days? I just want to go back to when I was trying to be white. Back to the 80s when I was trying to fluff my hair and wear poofy sleeve shirts. And I just wanted to fit in. Oh my gosh. Embarrassing. Embarrassing. I cannot. I know, yeah. I mean, kids in school carried knives in their pockets. I mean, it just was normal. Man, I wish we could go back to the 80s. I miss the 80s. The 80s were fun. It was fun. It's colorful. I say that, but I didn't fit in. I did not fit in. The 80s were all white, blonde hair, big hairspray, lots of Aquanet. Or, oh man, I'm telling you, China, that was my favorite time. So fun. But I mean, I wasn't white and I wasn't black. So you either had to be white or black. because you had the big like salt and pepper earrings, or you had to be white, which was all the plastic earrings, pastels, and all that stuff. But I wasn't either one. So, but I got along. I was more friends with the black people than I was the white people, because black people accepted me more than the white people. White people were mean. But girl, I wanted to be white. I wanted to be white so bad. It didn't work out for me though. Girl, leg warmers, pegged pants, pegged jeans. You remember we pegged our pants? Stirrup pants. I saw some stirrup pants. Jelly shoes. Oh my gosh. What did I I remember I got a perm. That was the dumbest decision I ever made in my life. I look like a freaking poodle. Because back then, all the girls had perms. Everything's coming back. I wish I had my swatches. Because swatches, people are standing in line killing themselves over a damn swatch. Freaking, yeah, when I was packing yesterday, I was going through stuff in my closet and I found pictures from 1989. And I found my prom dress picture. Y'all, that's embarrassing. Yes, jelly shoes in every color. And those things stink. Oh. Oh my goodness. I don't know who thought those were a good idea. Yeah. I love the 80s and 90s. It was good music, good movies. And they were no holds barred in movies, man. Just everybody was naked. They was showing boobies all day long in 80s movies. Didn't care. It was just free and fun. I loved it. See, I think that was the best time, because I don't think there was we weren't like hating each other so much back then. I think it was just fun. I mean, yeah, there was people picking on each other. I got picked on all the time, but I would rather have that time back than what we're going through right now. Right now, it just sucks. It's just super sucky. But the 80s were just fun. I hate that. I feel like I sound like my parents. Back in my day, oh my gosh. Can you imagine our old people home though, China? Think about it. Think about it. Think about when we get into the old folks home, what our karaoke and uh happy hours are gonna sound like. We're gonna be playing some Salt and Pepper, 2 Live Crew, some freaking Ice Cube, some dang Easy E. Oh my gosh. It's gonna be nasty. They just thought they had some nasty music now. Mm-mm. Mm-mm. Some Too Short. We're gonna be in the old people place. Yep. Oh man. We're gonna be saying, I don't see nothing wrong with a little bump and grind. They'll walk into the old people place. They be like, damn, mama. Oh my gosh. Oh man. Oh, they don't know. They don't know about us. Nope. 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 I think she's still deciding. Could be in there all like a virgin. Yep, just jumping around. The very first time. Yeah, we're gonna be jamming out in the old people house. Yep. Karaokeing up, doing wine night, playing our music. They don't know what to do with us. They don't know. Oh Lord, but I can't imagine when these people get old. We doing some WAP. Oh Lord. Lord, Lord, Lord. Oh. Oh. No, you'll be getting down, Gwen. I don't know what this judge is waiting on. Oh. I don't know what is so hard for her to decide of a mistrial. It's not that hard. The jury is clearly dang, she's still not back. And nobody assumes that about you, Gwen. Oh, she's still not back. Oh my gosh. Oh my goodness. Okay. All right. I think it's taking her longer. Oh yeah. Oh my gosh. So China, we were talking about the Julio Fulio trial because it's all over TikTok, right? They're talking about especially Sean Gathright and how he has no remorse, by the way. That none of them do, which okay, first of all, it's just gangbangers on gangbangers. But none of those kids gave two craps. But the Sean Gathright, everybody keeps saying he should be an example to all of these kids. Yeah, they didn't know him, but they're all part of a gang or whatever, right? But the Sean Gathright kid, he came from a good home. He came from a 2-parent home. Like, so everybody is just shocked on uh TikTok because he
minus the jury, and there was a mistrial motion made, and of course, we had an opportunity to
She ain't gonna do
consider it and research it. Anything else parties want to say before the court announces the ruling?
Nothing from the Commonwealth.
Just for purposes of the record, I just want
You
to
don't do
clarify the motion as it relates to juror number 38. She submitted a series of 3 questions, which again, we're arguing that helped, I believe, would aid the Commonwealth in planning out the rest of their case directly in response to her questions.
Thank you. And in response to the mistrial motion made regarding juror number 38's question, the court will deny that on the legal principle that jurors in this matter are actually the triers of fact. And under law, they can ask questions of the witnesses. Now, our courts aren't set up to do that. We don't encourage it. We don't normally do that. But it is not prohibited. And all the evidence has not been presented in this case. And both sides can adjust accordingly based on those questions. But again, jurors are the trier of fact in this case, and they do have the ability to ask questions and can actually question witnesses. So that's the legal principle there. Regarding the motion to mistrial based upon juror number 33, asking questions of other jurors, which means discussions prior to the case being submitted to them for deliberation. The defense has moved for a mistrial. The Commonwealth has joined. The court is going to deny the motion for a mistrial, and the case will proceed. The court's rationale is as follows. The determination of whether a mistrial is warranted depends on whether the juror misconduct probably resulted in prejudice to the moving party. The burden of establishing this probability of prejudice lies with the party seeking the mistrial. The standard is abuse of discretion, and to succeed on a motion for mistrial, the moving party must demonstrate a manifest probability that the misconduct was prejudicial. The allegations of juror misconduct arise, or if, the allegations of juror misconduct arise, the trial court may be required to investigate the matter to determine whether the prejudice occurred. In this case, the defense, which is the moving party, has not established a manifest probability of prejudice. The court did investigate the juror misconduct. Again, Virginia courts have delineated between misconduct inside the jury room and outside of the jury room. In this case, this would have been not outside, such as unauthorized communications with third parties or introduction of extraneous evidence, but it was misconduct confined to inside the jury room, specifically premature discussions among jurors. And case law has indicated that that is less likely to result in a mistrial unless it demonstrably affects the fairness of the trial. And in this instance, juror number 33 had questions about procedure of the jurors, not questions of fact. And I also want to make that distinction here. In addition, Virginia statute does provide a mechanism for addressing juror misconduct. And that is 19.2-262.01. So in summary, the misconduct here was not prejudicial, or is not prejudicial as found by the court, a legal decision, and a curative instruction can be given, and I will again bring them out and tell them that they are not to discuss the case, ask questions of each other about the case until it is submitted to them for deliberation. The case law that the court is relying on is Robertson versus Metropolitan Washington Airport Authority. Reiner versus Commonwealth.
Yes, Mark.
Caterpillar Tractor Company.
So
versus
yesterday, the
Colby,
two jurors had a question,
and the day
two
versus
different types of
Commonwealth,
questions.
in addition to the statute cited. All right, so with that being said, motion is denied and we're ready to move forward. Can we bring the jurors out?
Judge, I understand that the defense has an objection to the authentication of the video that the court has already considered, and that objection is going to require me to lay a foundation by
deny the
showing her
mistrial,
the video
which is crazy
and asking her to
because the
authenticate it.
process
We want to do that outside of the presence of the
even
juror.
I think
agreed
so, and what year her.
and said, we agree.
Rogers.
This should be a
That is correct,
mistrial.
Your Honor. Instead of bringing them out, and then having to exclude them again, so we could lay the foundation.
Because the jurors are clearly talking
uh,
amongst themselves. And one of the jurors' questions kind of insinuated that they were leaning toward a guilty verdict.
To the jury. Ron, I do have another concern, and that is at the beginning of the trial, the court ordered that all witnesses be sequestered back in the witness rooms. I think there's at least 3 rooms, and I think there's multiple witnesses in each room concerning that they may be discussing the case, may have heard about the evidence that has been presented in the case, and may be discussing that. And so I'm concerned that the court's ruling on sequestering the witnesses may have been violated, and is being violated.
Okay, and again, I believe there are over 20 witnesses in this case, and we don't have the physical space to give them their own separate.
She don't
homes.
care. She like, whatever.
But, of course, they are sequestered, and it's on the attorneys to identify them and to instruct their subpoena witnesses as to the rules. Do you have a basis for believing that they may have discussed the case?
No, I'm just believing that's a probability, of course.
Of probability just because they're sitting in the same room.
And they're talking, but of course I'm not in there. I don't know what
Okay.
they're speaking about.
All right, without more specific information, that the court is going to deny your motion, but feel free to voir dire them, regarding that, when they take the stand. Okay. And Commonwealth's witness that we're going to pre-clear the testimony for evidence.
Yes, Your Honor. Nina Farish, Dr. Farish.
Okay, bring out Nina Farish, please.
Wow. I mean, wow. Even the prosecution agreed that this should be a mistrial based on the jury's questions and based on the fact that the jury was talking amongst themselves.
Do you swear affirm
And the
the
judge
testimony
said
you're
no.
about to give is the truth, whole truth, and nothing but the truth? Okay.
Watch your step, there's a stair, and the chair and microphone are adjustable.
Wow.
And, Ms. Farish, we're going to take up some of your testimony outside of the court for the jury. We will get any objections and evidentiary issues. And upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's
I mean,
happening.
he's facing 40 years.
Should you have any questions, we'll start with Tom. Yes, Ms. Roberts?
Before the video started, I would like wanted her during the video prior to her actually speaking.
Okay, and I don't know what order Mr. Jenkins was going in. So do you want to start with the questions, Mr. Roberts?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
This was supposed to be a 2-day trial, y'all. 2 days.
Good morning. Could you please tell us your name and how you're employed?
Nina Farish, Human Resources Director with Newport News Public Schools.
Were you employed in that same capacity in January of 2023?
Yes,
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Rich Neck Elementary School that occurred on January 6, 2023?
Yeah, why do we got to get these impartial ones?
As
We're like-
part of your investigation, did you have occasion to interview numerous people?
yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom,
Okay.
recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes,
And what was, prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
assistant principal.
I know, we always got to be
And
down with it.
do you see Dr. Parker in the room right now?
Yes,
Could you please just point her out for the judge?
sitting.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes,
All right. And was that was that interview conducted in person on Zoom or some other way?
via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think does.
Good morning, ma'am. How are you? Great. So regarding any video that was produced, did you keep, or were you the sole custodian of that Zoom video?
Yes,
Okay, and where was that video maintained?
on my computer,
Okay. Did anybody else have access to your computer, or was it just you?
just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins, the Commonwealth?
No, I I'm trying to remember the name of the law firm, because
So
as I recall.
so the civil
Mr.
attorneys,
Jenkins was not the original attorneys.
the civil attorneys?
Correct.
Okay. So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes.
When did you review that video?
I reviewed the copy that I still have, and I reviewed it to refresh my memory.
Okay, I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question, because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video, and
Yeah.
you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into the possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay.
Okay, the next case, I'll try to find one where we can almost be for sure that the defendant is a guilty, horrible person. Okay. Just disgusting, horrible person. Even though we're in a society of
Okay,
innocent until
and,
proven guilty.
This recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it
In the cloud.
Is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original, because I've never, except when subpoenaed,
Okay.
made a copy.
Okay. And again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you. I'll tell you what, I'm going to let Mr. Tik say it again.
Good morning, Ms. Farish. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
No.
And so the actual video was something that you downloaded from Zoom or was provided to you later via Zoom, correct?
Repeat that question.
You said, I believe your testimony is that Zoom recorded it. You pressed record on the Zoom platform.
Correct.
And Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording,
Mm-hmm.
and it can play for me.
Okay. Thank you.
Okay, and one moment, Dr. Parrish, any further questions while here before we?
Just arguments at this point.
Okay, your arguments are towards the video?
I mean, we just think things should be fair.
Cannot verify the accuracy
And I don't believe this is fair.
of the video that Commonwealth has. She hasn't viewed it. She's testified that she cannot.
I think this woman has suffered enough.
Whatever video the Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video.
I mean, her career is over.
Artificial intelligence and alter it. She testified that she can't.
I'm pretty sure she feels absolutely horrific. I don't know what more could have been done.
Yes.
I mean, to hold her criminally responsible is a pretty.
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of the Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having to examine it ahead of time to determine its accuracy.
Judge, if I may,
You may.
the two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file,
And if you can't, that's fine. I just didn't know if you can.
the total duration of the 3 is, let me make sure before I say.
Yeah, I think that the money would have been better. Actually, I think the mom should have been held more accountable to this. I think the mom should be on
16
trial.
minutes and
I think
36
that
seconds is the total
We should
duration.
be finding out where the ball was dropped
Yes, Mr.
in this
Rogers?
child's care.
Has already admitted that the video has been altered. So
I think there should be more attention focused on apparently the mom was she smoked pot. She lied on her application to purchase the gun. I think that should be focused on. I just think that there's a lot of things missing.
Okay. Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that, if she is able to say that this is an accurate, fair and accurate representation.
That we could be doing to improve our.
Now, what authority indicates that it can't be redacted to the relevant parts and that you cannot mute?
Like, you know, I think there's some things that could be improved upon.
The names of minors involved.
I mean, y'all know me, I'm a 2A'er, but could we not maybe do drug tests? I don't know if that's an invasion, probably an invasion of privacy, but I mean, I just feel like there's things that there's steps. There's something that we're missing.
And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't.
Okay, but the other thing you're saying, if they get parts, I want the whole one.
Oh my gosh.
Your Honor, I'm going to object to just a part of it because of the importance of context. If some of it comes in, I think that jury's entitled to it.
And Commonwealth, they're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back up, Mr. Jenkins. How long is the entire interview?
Oh, I will have to look at that.
That's when I asked Mr. Rogers, are you asking him to play the entire interview?
Yes, ma'am.
Okay, that's what I want to know. How long is the interview?
Oh, she just gonna let the whole thing in then. We letting this thing ride. She's like, I got dressed up for this. I put makeup on, earrings in. I fixed my hair
The
today.
whole video is 28 minutes and 58 seconds, I show. Let's see if that's right.
Okay, dude, that's nothing. Okay.
So you'll play the whole video for the jury, should it meet the other identification things. Anything else, Mr. Rogers? Okay. So Mr. Jenkins, what are you prepared to play now for the witness?
Well, I can play the whole video if that's
There
what
you
it's
go.
going
We'll
to
just
take
play
to authenticate it. If defense counsel would agree to let me show her a freeze frame and verify, we can do it that way.
Mr. Rogers?
So I'm gonna ask that she be shown the entire video, but then when it comes down to the presentation of the evidence, then I would suggest that the Commonwealth can show clips at that point.
Yep.
I want the Commonwealth, I want the jury to have the whole video.
Well, look at Mackenzie Shrilla. If y'all ain't
I
watched
think I
that,
understand that the defense is wanting to admit the entire video into evidence
the crash on Netflix
on
shit.
the disc so that the
Her
jury
parent.
could see the whole unedited,
They created a
unredacted
monster.
video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that, it has been properly vindicated.
Okay, all right, so, okay, we agree to proceed in that manner, except she doesn't need to watch the entire thing. Ms. Perry, she's gonna show you portions of the video and ask you questions about it. But in terms of the entire video, if at any point you say that that's not accurate, please let us know. But I'm.
Your Honor,
Yes, Mr. Dixon.
just before we start, I would note that Mr. Commonwealth has indicated that all of the 3 clips have been melded into one file, so they've been joined together, which I think obviously jump would mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're in one melded video that's combined into one file. I don't think that would be fair to Dr. Parker, because it would leave out. I'm assuming that he's jumping. Having not seen this video, the splice one, it jumps. He's saying that he's joined 3 clips together into one file that plays continuously.
Okay, well, let me hear from Mr. James.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm sure Your Honor may as well, that I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips, because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters, the people move oddly, and that's when the new clip starts.
Understood. Okay, so what is the defense motion? Because Mr. Rogers said it's okay to play it, but just wants to get the entire video for deliberations. Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
Yes, sir. I think that that's an alteration that goes beyond using people's names and clicking, making splices that are obvious to the jury. I just don't think that should be.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the counsel is free to offer whatever they'd like. They have a copy of the video.
No, we don't agree to admitting a spliced, altered video into evidence. We just don't.
Okay, give me the authority that indicates that that's not admissible. I'm not aware of it.
oh my gosh.
Okay, and Mr. Rogers, what case law has you handed up?
Your Honor, this is, Commonwealth, Supreme Court of Virginia, December 19th of 2024. And so I will begin. But the rules begins at, you'll see.
Oh my Lord, just do the video.
That's probably like 6 pages back.
Sir?
Says, beginning back her
It is idolatry.
photograph or
I was waiting for
verify the testimony of the witness.
this collection of clothes to come out. It's already sold out.
Is admissible in evidence.
It literally just came out.
By the individual.
Gone.
And then I'm just gonna go on down.
All I wanted was a shirt.
Or a witness that speaks for itself, video.
It was the Calvin Klein Jungkook collection.
Adequate foundation ensuring the accuracy of the process producing.
Literally sold out already.
This splice video is not something that she's gonna be able to.
I just wanted a t-shirt.
be accurate. And so, going down to paragraph 2223, focusing the authentication quality on one street moment with two more.
That's what China needs to make BTS stuff. I don't know. Her daughter's store. China, her daughter has a print shop. They do t-shirts and tumblers and stuff on for door hangers and things like that. I need her to make me some BTS, some Jungkook stuff.
And as far as it's obviously the Commonwealth is going to be presenting a video that points more to Dr. Parker's guilt than innocence. So
Yes, are y'all making any BTS merch? Because girl, I mean that's money. And I'm moving to my new house. I need some
obviously
Aryang. I want some Korean stuff.
So she can't verify the
That's what I need. I'm gonna send you the designs.
Judge, would you like me to respond?
Good. That's awesome. Heck yeah. Oh, I have not seen those. Let's see. I'm gonna look them up. Hold on.
So the court is going to allow the Commonwealth to play the 16-minute clips.
Everybody has a manifesto these days.
To the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I know the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempt to authenticate this, and then we can get moving with the jury trial.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the three different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Was that
Is that still a defense request? And the Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. Yes, sir, you may proceed.
Thank you, Judge.
Okay. So Dr. Parker, thank you so much for joining me today. I'm here to first
Finally.
ask if you are giving permission for me to record this session to discuss the incident that occurred in Richmond on Friday.
Yes.
Okay. So as part,
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
She's only seen my client's face. She certified that I was just gonna ask it.
Are y'all making BTS stuff, China?
No way she can verify this.
What are y'all bulk ordering?
The 16-minute clip is accurate. She has to see it.
Ms. Jenkins, if you just jump to 2 other sections, if you're able to,
Mhm.
and play about 10 seconds and ask the same questions.
Okay, I can. Oh,
Oh,
sorry.
sorry. I'm seeing at the bottom of the screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on video or if you have another cursor mark on your laptop that's showing the different timestamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was
Okay,
recorded.
understood. Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those are the only 2. Okay, so help me understand.
And Dr. Ferris, does this still seem to be your interview with Dr. Parker?
Yes.
Okay, I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday. Okay, all right. So just to be clear.
And Dr. Farish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
Judge, with that, I think we've laid a sufficient foundation for authentication purposes for this video.
Yes, sir. Anything additional from the defense?
No, just to try to stress the whole point of authentication is to verify accuracy. Your Honor, it's going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in that possession of those other attorneys or any IT professionals, any other person between the chain from first, the other attorneys, and just showing her those very few seconds that she's not verifying the accuracy. She's verifying that.
Nice, China.
Talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Okay, so again, the defense will continue to note their objection for the record.
And I'm still going to allow it.
Again, it's going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related to that? Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter. All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. It is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
Sheriff, it's time to bring the jury out, and we do ask all parties to stand while the jury comes out. If you're able.
Your Honor, I'm going to step out in a second.
Okay, step out, Mr. Rush. Yes, sir. We'll wait till you come back.
Thank you.
I'm sorry, everybody. Get your knees in your back.
Okay, so I'm looking at this manifesto, whatever, from these 2 kids. First of all, how do a 17 and 18-year-old get filled with this much hate? Second of all, they're contradicting themselves in all of this stuff. They're talking about they're blaming the Jews for everything. But then one of their heroes is Islamic. Omar Mateen. That's one of their inspirations from the Pulse nightclub. And another one is black, Solomon Henderson. But yet they hate black people, Jews, Islams. They are very contradictory. They're talking about supposedly keeping the white race, which is really weird. I don't understand that. I will say this though, they don't say anything about Asians, so we good. I don't understand why. Where is all of this coming from for this 17 and 18-year-old? They call themselves what do they call themselves? Some sort of Christian eco-fascist. I've never heard of that. And accelerationist, whatever that is. The only solution to the current state of the world is to accelerate towards the complete and utter collapse of society. And the only way to liberation of the white race is through violence, sabotage, and revolution. Well, I guess they accomplished that by taking their own lives. So, great job, guys. Great job. They had literature. Oh, accelerationist named William Pierce, the Turner Diaries, and James Stephen. I've never heard of those books, but I'm not one of those kind of people, so I don't know.
Hopefully keep a swift pace through the day. As usual, we'll try to break around one.
I mean, I guess just for educational purposes.
Evidence for the day. And if you need any breaks, let me know.
We might know who that stuff is, but I don't know who that is.
The juror box as a whole, but we have that cautionary instruction.
Accelerationist.
Research this case outside of what's presented
Accelerationist.
Courtroom, not to discuss it with others.
I don't even know what that is.
You, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction. Again, amongst yourselves, please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in the Commonwealth will start their direct examination. Mr. Jenkins.
Thank you, Your Honor.
What's a spike?
Good morning again.
Sorry if that's offensive. I don't know what it is.
Would you please tell us your name and how you're employed?
Nina Farish, Human Resources Director for Newport News Public Schools.
And Dr. Farish, how long have you been in that role?
For 4 going on 5 years.
And so were you in that role on January 6, 2023, and in the month of January 2023?
Yes,
And do you know someone named Dr. Ebony Parker?
yes,
And was she employed by the school system?
yes,
How so?
as an assistant principal,
Okay. And is she in the courtroom right now?
yes,
Could you please point her out?
yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Rich Neck Elementary on January 6, 2023?
Yes,
And after that incident, were you called upon to investigate it?
yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Rich Neck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes,
Did you conduct an interview with Dr. Ebony Parker?
yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes,
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, defense has objected, and of course allowed that the video will be played. I don't think it requires dimming, but do either of the attorneys want the courtroom to be dimmed?
Not necessarily.
Okay, you may proceed.
Okay. So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Rich Neck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer the questions honestly. Also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack.
Do you know? Go ahead.
So, Ms. Kovac, we're allowed to use names, right?
Yes, ma'am, please.
Okay, so Ms. Kovac was the one who informed me of this. And she said that she had already asked the student, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess. So I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter growth assessment, printing off tickets and such. So I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she says, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So I don't know if she went outside or not, but there was a comment that said, well, we watched him closely. I assumed she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between them, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. The meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, should we check his backpack? Did we check his backpack? Mr. Rawls, after that situation was settled, came back into my office and he said, "Hey, did you hear what they said about?" I said, "Yeah, I heard." I said, "But we checked his backpack." And again, I'm still using we, but it was Miss Kovac. I said, "His backpack was checked, we didn't see anything." And he says, "Oh, okay, did you check the person?" And I said, "Ooh, no, we didn't." And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those were the only two.
Okay. So help me understand, what is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did in previous times before, we had 2 other students who also were reported to have a weapon. And we, asked the student, do you have something that say, no, we do have someone else come in with us to look in their backpack. But we never searched a student. So because we didn't, Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for mom to come in.
So in the past protocols of what you've done, correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls, and then the second time it was an incident of a parent had already called the police because the report was given to her from her son. So she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mrs. Warner on that Friday come to you and express concern about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Warner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, okay, and then she left. So I told Miss Kovac, because they were going to go back as a kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Miss Warner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't. She didn't say that to me.
Okay, all right, take your time. Had Ms. Warner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so has been on a modified schedule since the beginning of the year. His acting out was that he's extremely defiant, and he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15, 20-minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Warner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. We told, hey, you don't know the damage that it is to the teacher's phone. We'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Ms. Foster, and she said, I really think I'm gonna call mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Warner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do. Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Ms. West reported to Ms. Newton was that he was like pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that that was what was reported Wednesday, that's where I think that came from.
Okay. Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. Prior to Friday, had anyone, Ms. Warner or anyone reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So staff stating that administration knew, what is your response to that?
Could we pause the video?
Yes, you can pause it. Yes, sir.
Can I have just a moment to talk to the council, and then I think I have an objection.
A brief moment.
There's a lot of, I'll say hearsay statements that are being propounded by Ms. Ferris, things that other people may have said. And so I understand the video is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Ferris, I would submit to the court that I believe those are hearsay. Any statements that she is alleging was made or declared by another party, I would submit as hearsay. And I would ask the court to instruct the jury not to consider statements of Ms. Ferris or what somebody else may have said, but only consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of curative instruction after that.
So I will, again, continue to play the video, but I will grant a defense motion that will give a curative instruction. So we'll prepare that when it's time for instructions. Whose testimony they can consider from this video and the hearsay. All right, you may proceed, Mr. James.
I don't know.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration knew. What is your response to that?
I don't know. I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Warner, was asking for. Like, just, I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Warner were reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag?
So in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay.
I just want to point out.
Did you talk to your resource officer that day?
She was not there.
Okay.
During
The
testing,
resource officer, the actual, I didn't call, I didn't call. And our security officer, Ms. Lee, she leaves every day at 2:00.
She leaves at 2, so Ms. Lee was.
I'm sorry, not 2:00, 12:00. And she comes back after McIntosh's dismissal, for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
so during testing, administrators are stuck where they're at. I understand.
Dr. Parrish, was what you just watched a fair and accurate
But you do
depiction
delegate a
of
lot.
some clips of a longer
The
interview
testing,
that you did with Dr.
the
Parker?
state does not mess around with testing.
Judge, at this time, I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker
It's a
that
very
contains the
straight
clips that have just been shown to the
system.
jury. I would move to enter that as Commonwealth's 2.
I so introduced over defense's previous objections, which were made.
And there's usually only one administrator in charge of testing for the entire.
And Judge, at some point, I will need to take a moment to get the full and complete video saved to a drive. And at that time, I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Farish, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes,
And you do that for the school district?
yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes,
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year?
yes,
Do you have that document with you today on the stand?
I did.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Yes, what's the objection?
Dr. Foundation, Your Honor. Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
The court has already ruled on that. It is
We
a,
ruled on hearsay, we didn't rule on foundation.
okay. Well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself, and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Basically,
Yes, Your Honor.
it should,
So,
like,
thank you, Dr. Ferris. This is page 28,
all
a
come in.
paragraph that begins, principals and
Yankees
school
trialing.
security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Rich Neck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay, please give me just a moment. I'd like to direct your attention to page 18.
Yeah, I'm going to request some idea on this, on the her foundation of knowledge regarding this particular document.
Okay.
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room because admissibility is not a factor for them.
Yes, sir.
And what's the basis for this again?
I don't think the proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not going to allow this to one here at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Ferris, let's back up. Is the multi-hazard crisis plan for 2022-2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes.
Official records?
Yes.
Okay. And is what you've brought here today an official record of the school that was in effect at Rich Neck on 2022-2023 school year?
Yes.
Foundation established, you may proceed. Objection is overruled.
So I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
18. And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
Your Honor, I'm sorry, I need to pull that up.
10 seconds.
I'll provide it, Judge.
The judge is like, you got 10 seconds.
All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and/or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and/or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Parrish. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading Weapons Threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading Weapons Threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area, evaluate the perpetrator, evaluate the perpetrator,
Dang it, there it went, Mark. You
Isolate.
had to say something.
consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Ferris. That's all the questions that I have for you. Please answer any questions from Defense Counsel.
Your Honor, if I may.
You may.
Well, it's still morning. Good morning again. All right, a lot to unpack. So let's go over again. You are the HR director
Yes, sir.
for Newport News Public Schools, and you conducted an independent investigation of this whole incident. Is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that?
Objection. This goes beyond the scope of the direct exam and, is also asking about the investigation and other things that I didn't go into. It didn't.
It was elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I'm
I was
trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, Ron.
And what part was your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all.
All right, okay, but if you plan to get there, I think he's going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay. So you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay. And as a part of your investigation, did you do the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Rich Neck Elementary School?
You want me to describe, you're not asking me how many?
I'm asking you how many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Rich Neck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying. She's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response?
Your Honor, she's testifying as to what she observed. So, she looked at videos. She's testifying as to what she observed on these videos. So I'm not asking to introduce these videos. I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on the videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on the video? How would that also be, by analogy, admissible?
No, obviously we have already submitted video into evidence.
Well, one video. Are you talking about that video or a different video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events
so
that they
confused right now.
record. if I had the videos, I can, I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Okay, 2 questions, or I guess 1 rule. Yes, she cannot testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Yes.
Obviously, evidence is coming in through the Commonwealth's case in chief.
I'm saying, is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay, so again, my ruling is that she cannot testify as to what she observed on the video. I sustain the Commonwealth's objection. My next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object it, and the court can rule.
Yes, sir. And again, to the attorneys, I know that there's been a lot of objections, and there were a lot of objections yesterday, and swirls all over, and sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Mr. Rogers.
Okay. Other than Dr. Parker, were you able to determine the conduct of any other employees that were at Rich Neck Elementary on January 6th?
Okay, and don't answer. So, and your question was, she able to determine?
Observe the conduct, behavior of other parties, other staff members at Rich Neck Elementary School.
Okay, and the reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication, that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not produced. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed. And again, if it can't come into the front door, it cannot come into the back door. Next question.
All right, I'll go to the, let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes.
Okay. And so you're the custodian of this document, is that correct?
Correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students,
Yes, ma'am.
the code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents to be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay, so would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response?
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is,
Right.
but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes,
Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now, which is the province of the jury to decide.
Wow.
And your response?
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I asked her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are a province for the jury, but how is the finding of this school investigation not come, well, how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Parrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it in over the Commonwealth's objection. The court's rationale is the Commonwealth has introduced the school handbook, the policies and procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination. And what the school found in all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case. And that is for the fact finders. And that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that supports basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Swerner. So I meant Swerner. Could you answer the question in regards to Mrs. Swerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding the multi-hazard crisis and emergency management plan, this is a plan for each individual school. Is that correct?
Correct.
Okay. And are you, who's responsible for producing this document, if you know?
That would come under our safety security department.
Prior to this incident happening, were you familiar with this document?
I know that the schools have them, if you're asking if I'm familiar with this particular one prior to that incident, no.
Okay. And so you have become familiar with this document since this incident has occurred, is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes,
Okay, so this document would also apply to the teachers in the classroom, is that correct?
correct,
It would have applied to Ms. Kovac as a reading specialist, is that correct?
correct,
Mr. Rawls in his position, is that correct?
yes.
All right. And so based on these two documents, was there anything in these two documents that prevented Ms. Warner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No,
Okay. Is there anything in these two documents that prevented any of those four individuals, Warner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
no.
So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to.
Speak up for me, Mr. Ross.
Okay. Did you hear what I said so far?
I heard you say you were gonna go to page 60.
That's correct. Okay, and even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Wait, say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Response?
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can answer what does the manual say, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay, so I'm going to ask it in a different way, if I may. Ms. Warner, Ms. Kovac, Mr. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection. He's asking for an opinion of whether they should have followed certain procedures.
Just have a very calming
Well,
voice, considering she's in HR.
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed. With that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those 4 individuals, if they believe that there was a weapon, they should have.
Objection, Judge. This isn't the question that the court. He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented with?
Was it whose responsibility?
Ms. Warner.
That's the same question, yes, that I sustained objection to. Next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Ms. Ferris, Dr. Ferris, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Okay. Your Honor, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you, Your Honor.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they can. Understood. And I think you got something, Mr. T.
Oh, thank you.
This is very odd that the defense attorneys are like tag teaming questioning.
Good morning again, Ms. Ferris. Are you Doctor or Ms. Ferris?
Doctor.
Dr. Ferris. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the video was, the entire video is 28 minutes or 28 or 29 minutes?
Cross-examining HR lady.
Based upon the timeline I saw.
Okay. And you were shown about 16 or 17 minutes, correct?
Yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets. It's the whole video.
Okay.
This is so confusing.
So I'm going to pull up the video, the actual video, the whole video.
I'm very confused. The jury has got to be confused. This
What
is
I'm going to object to is that I don't know what the relevance of this is.
Okay.
I don't know what's going on,
Take
China.
a moment to respond to relevance.
This should have been a mistrial this morning. These two defense attorneys, like, they're very
I'm going to ask the
unorganized.
council not put that up on the screen until we've addressed.
That's
the
fine.
Okay, he's objecting to relevance. What is the defense response?
It's relevant. The
Thank you, Mark.
witness has testified that she does not believe that the video has been cut up and, certain parts edited
Did
out.
she say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay. And what are you purporting to introduce and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay. And again, we agreed that the jury would get the whole video for deliberations. So your objection, and what you're gonna play is a part of this whole video.
Yes.
Okay, and so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has, which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my ruling, I'm going to allow it in over the Commonwealth's objection. The basic thing is the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth. The opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's the court's basis. You may proceed, Mr. G.
Thank you, Your Honor.
Oh my word. At least she didn't actually take
And
anybody's
Dr.
life.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay, the whole name, not initials.
Correct, the
Okay,
whole
but how
name.
are we dealing with that, Mr. G?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid
We're
it.
talking about, again, audio and press coverage to the world.
I understand.
So
Yeah.
you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay, you may
But just to be safe, I'll just try to elicit the testimony from her directly, and then if I need to, I'll play the portions that I
Are you
need to.
playing video or not?
It would just depend on her answers.
Okay, you might,
Okay.
okay, but understand we have that
I
cautionary
understand.
instruction. We are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor. Dr. Farish, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to two other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I'm gonna just refer back to my notes.
This seems like it should be a simple trial. Is there a such thing as a simple trial? Like an easy, like just ABC? Is there, I mean, I guess there, I mean, oh my word.
Dr. Parker was not just in her office ignoring the rest of the school during the testing, correct?
Objection, it's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor. From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were 2 other student issues that she dealt with in the school, correct?
Objection, that was the most recent question. It's been asked and answered.
I want to narrow down and go down the path of asking about these 2 other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farish, of what was going on regarding her conversations with Mr. Kovac and Ms. Werner, she also mentioned that there were 2 other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on, that's the question. What's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it, go ahead, so overrule.
Okay. Do you need me to repeat the question, Dr. Farish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay.
Or a student who was an eloper. and
An
there was
eloper.
something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Farish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge.
Objection.
Hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And her foundation for having that knowledge or information, so sustained.
Okay. You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct?
Yes.
You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're gonna need to address this at sidebar.
I mean, did she
I'm asking
know?
her what she advised Dr. Parker during this interview.
That was my first thought when she said keep it confidential. And now here it is being used against her in a criminal case.
According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember the phrase,
Man,
is that they were watching him.
Watching him closely.
Correct.
Okay.
She didn't, I don't remember if she testified in
So
the.
is it your understanding that Dr. Parker had been told that there was no gun in the backpack, and also that he had been closely watched during recess.
Objection, can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
Saying, can you rephrase to clarify what you're referring to?
Okay. Well, I've already asked the questions. I'll move on.
Oh. Let me see. I think she almost might have to, because
Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
it's
Okay.
really her word. I mean, it's really her word. Yeah, 40 years. I mean, it's all, how did they come to her and say it?
Noise, I'm not sure where it's coming from. I don't know if somebody's cell phone or, but if we could try to take care of that, it's very distracting.
Also,
Yes,
the
I keep
teacher,
hearing it, and it's distracting.
Okay, well,
Yes.
the sheriff will be on top of
the
that.
victim
And I'm
is
hearing
claiming
you.
she
Yeah, we'll
feared
work.
for her life
All right, thank
from
you.
this 6-year-old,
12:23.
yet she didn't do anything. She didn't.
Okay, they're good. Okay, I'll proceed with your cross.
Thank you. Dr. Parker also testified or said to you during the investigation that
Sound like I'm victim blaming, but
Ms. Werner never stated that the student had a weapon, right? May I ask what you're reading?
It's a transcript of the video.
Okay. Do you have any independent recollection of
I
what?
don't remember her saying Warner said the student didn't have a weapon. I asked her, did Ms. Warner ever say she had concerns about the student and the student being a threat to her or feeling unsafe?
Okay.
no, she did not say that. That's not
Do you
what
recall
she
when the
did.
video was
I just
played here in the
watched video.
courtroom?
I remember.
That's what I was trying to remember if.
She did not say
Ms.
that.
Warner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
She did not say she felt unsafe.
Do you recall the video today where Dr. Parker was speaking to you in an interview, and she stated that Ms. Werner never came to her and said that the student had a weapon?
And she never felt unsafe.
That, yes.
Okay. And everything that Ms. Werner related to Dr. Parker was about behavior of the student, correct?
Correct.
I mean, he's 6.
She also mentioned that they had, prior to this incident, that they had 2 incidents at the school where there was a potential weapon possessed by a student, correct?
Now, these days, people have to get on the stand, I think, Mark,
Before,
more.
prior to January 6, 2023.
It's
Correct.
getting to the
Okay.
point where if you can't
And she also
yourself,
mentioned
nobody
to you
else
that
can
they
do it.
never searched the student without the parents' consent, right?
I had to get on the stand and defend myself.
Okay.
People say people that do that are narcissistic or whatever. Nah, bitch.
And she was also managing state
That
testing
policy
that
and
day.
procedure manual was not going to defend me.
Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
I don't think. First of all, aren't you supposed to ask? Can I?
At any point, did you say something to go to?
She-
Oh, okay,
I just asked for a moment to refer to her notes.
okay.
She didn't ask. She said, "I'm going to." Oh, it was my honey. I had to go to court a lot because it was part of my job. But this particular situation, we got sued because I made a stop. He shouldn't have been stealing. First of all,
I do not recall making that specific statement.
but
Mhm.
it was my
Okay.
job.
But you do agree that this, based on your investigation, that this is
particular
not
case
something
is
that
not
was
fun.
foreseeable.
Because
Okay. Did you ever make the comment
sued,
in the civil trial of this matter that this was something
and
that
I had to prove
you
I was
could never
doing my
have
job.
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. He can ask her what she believes today, now, but not what she said.
I got sued. Yeah, but I won.
Like you said, from the civil trial, does that make it in court, or am I missing something here?
It's out of court because it's not within this
This
proceeding.
proceeding.
Yeah.
She says that she cannot recall, she could not at that time recall making a statement, and I believe I was asking her
We had a
about
very good attorney,
the actual report
and I was
itself
doing my job.
that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, hold on before you answer. So, assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
In your position, Mr. James?
He's feeding her the statement and just asking her, say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood, and your response to that, Mr. T.
Your
How
Honor.
is it admissible? What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question, Your Honor. She's already answered
Yes,
that
draw the
she
question.
has
Just get
determined
it
that
over with.
it was
Stop.
not foreseeable. So I'll withdraw the question. Okay.
Oh my
No
God.
further questions.
There's nothing more tense than being on the witness stand
Yes, sir.
and I'm telling, and go through a deposition. In a deposition, it's no holds barred. I tell you what,
Dr. Farish,
they can ask.
much has been made about your investigation. As part of your investigation, did you complete a Rich Neck investigation report?
Yes,
And do you have that report with you right now?
yes.
May I approach, Your Honor?
You ain't?
I've been in a deposition and
Sure.
I
believe you have a copy.
I've had to have my attorneys stop a deposition because the other side was so brutal. They go digging. I mean, they dig deep into like your past. It's disgusting. And they start bringing up stuff that literally has nothing to do with nothing. And I literally had to stop the deposition and was like, yo, you can't talk about my family. You don't talk about my kids. Don't talk, like, what the flip?
Judge, I provided to the defense counsel a copy of the plan. Do I need to wait?
Review what you're presenting to the witness.
They started going after stuff that were like, it was uncalled for. It was very unnecessary.
Okay, you may approach.
Thank you.
Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
And civil cases are dirtier than criminal cases. Civil cases is all there's no borders. That's why when people can't get you for criminal stuff, they go for civil, like wrongful death suits and stuff. I mean, I've never had that, but I'm just saying Like when people can't get you criminally charged for stuff, that's why they go for wrongful death, civil. Like what they did to her, this woman right here, she got the civil suit. They won that, so that's why they're going for the criminal charges. And I think that's why she'll get found guilty on the criminal charges, because she's already been held accountable civilly. Yeah, it's crazy.
All right, so is that a fair and accurate copy of your complete, full report of your investigation?
Yes.
All right, Judge, I move to admit that as Commonwealth 3, I think.
Your Honor, I'm going to object. This is the investigation, confidential information, like investigation report that contains hearsay from other parties. It is not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about, cherry pick little pieces that they want to talk about. And I'm seeking to admit the whole document so the jury can see it for themselves.
Ms. T?
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. It's monitored, so for the direct examination. This is a report that contains hearsay statements from other parties. Just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video, giving them a full report complete with hearsay is beyond the bill. It's not admissible.
Okay, let me see the document.
Of course, may I approach the, oh,
You may.
the deputy has it.
Pass
Yes,
please.
of course.
Thank you. Appreciate you.
Oh my goodness. This should have been a mistrial. Because this is, well, we thought those attorneys in the Josie trial was petty. These attorneys are like super petty. But don't get me wrong, you want your attorneys to fight for you. I can tell you though, when you're in the middle of a case, you do definitely forget like what you're there for, because it is a fight. It's just a battle of who's the dirtiest, who can pull up the nastiest stuff on the other person. It's gross.
Dr. Ferris has not been qualified as an expert.
It is a lot of mudslinging. And it's sad. It's sad that it has to be that way, but if you want to win, and it's all about winning. But you got to win by the facts. You can't. I say that out of both sides of my mouth because you play dirty. But you gotta have facts. Man, these lawyers are snotty.
The court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in, the middle does not. I will remove the statement myself. And does the Commonwealth want the portion removed to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. We're Madam Clerk is amazing. Commonwealth, this we're at 3, Commonwealth 3. Rejected 1, rejected Commonwealth 1. Okay, you may proceed with your redirect.
Judge, may I retrieve Commonwealth's 3 from the court to bring to the witness?
Yes, and I'm gonna ask. Yeah, I do. Your staple is worth just as good as my staple. So I'm gonna make a mess. Oh, yes, sir.
Dr. Parrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth's 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Your Honor, again, I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Mr. Warner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth's
How many people did she list?
and return it to the court.
Thank you.
But she didn't just put all the blame on Miss
Now,
Parker.
Dr. Parrish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Rich Neck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district.
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth's 4. I will have to retrieve it from the witness.
Okay, you may approach.
Before that's admitted by the court, could I have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins, and you can pass it to Madam Clerk. I won't receive it until I get from the defense counsel.
Prosecutor.
The court order is ruled that it come in, so.
All right, so this is marked Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Farish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools, Richland Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted as Commonwealth's 5. May I approach the witness?
You may.
I just want to make sure our objections continue.
Yes, continuing objection, which was previously ruled on, and for the record was made contemporaneously.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, sir.
Oh, of course.
Briefly.
Briefly, Dr. Farish. Again, the portion of the report that was just entered into evidence, your investigative findings, you were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Werner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker. Your finding is that none of them responded adequately, correct?
Objection, Judge. I think that misstates the evidence.
To respond adequately, I do think it's a misstatement. Can you rephrase?
Okay, all right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named? Ms. Werner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims, and Dr. Parker?
Yes.
Okay. No further questions, John.
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically.
That was the one.
We took it away from you.
Okay,
Can I,
that's okay.
can I please retrieve Commonwealth's
You may.
5, the rights and responsibilities handbook. And I can give you a page setting. I'll direct your attention in Commonwealth's 5 to page 28, the paragraph that begins principals and school security officers.
Mhm. Principals and school security officers, under the direction of a school administrator, may search students and student property.
All right. So given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
The school, under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right, thank you. I don't have any further questions, please.
Oh my.
Okay, so this, so that paragraph, it starts out principals and school officers. And then it, comma, under the direction of a school administrator.
Objection, I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Are you reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes a principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay, so if I take out, it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, the same. Next question, Mr. Rogers.
Yeah, that's all I have.
Okay, the status for this witness, may she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to.
Mr. Rogers?
Yes, Your Honor, we agree.
We concur, okay, all right, so Dr. Bailey, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony.
Yes.
Okay, and you'll be informed when you receive question ends and when you're released from the witness obligation. Okay, thank you, ma'am, and while I step as you step in.
Thank you.
All right, can we do another witness in about 10, or start with another witness about for 10 minutes or so? I just want to use up our time.
Before we call another witness, I would need to step out, so.
Okay, yes, Mr. Jenkins.
If we're going to need to take a break here, it doesn't make sense to call another. The break will take 5 minutes and then we'll only have 5 minutes of a witness. Before
Okay,
one
so
time, so.
it is 12:51. We will start our recess for lunch. For the attorneys, are there any motions, objections that we need to take up before we resume evidence? Meaning, I'll tell the jurors to report back at the jurors at one time, and I'll tell you all a different time if we need to work out issues.
What time are they on? How are they at 12:51?
Okay, so I'm gonna keep a tight schedule. Jurors report back at 2, attorneys report back at 2, and We'll
This is the
get going,
weirdest time
and there
zone.
should be lunch back there again, jurors. Your recess instructions. Do not discuss the case, do not research the case, do not allow anybody to discuss it with you.
We are on the weirdest time zone in Virginia. It's so odd. Okay, so there's another trial going on in Georgia. I don't think if they had opening statements, we didn't see them. But this is a man who's accused of killing his girlfriend.
Come back, Martel. All right, anything we need to take up before we bring our jury back in?
Cobb County.
Go ahead. Bring them back in. You can
Um,
publish when they come back in.
this is in Atlanta. This is Eugene Lewis. Jacque faces multiple charges, including murder, aggravated assault, second-degree arson, concealing the death, and tampering with evidence in the death of Beauty Couch. Couch's family. So police were called to Joe Jerkins Boulevard and Landers Street for a car fire. Couch's body was found in a nearby woodline. Oh, her name was Beauty Couch. Couch's family told Atlanta News that she had been stabbed several times. So this is the trial for Beauty Couch. She was an influencer in Atlanta. We missed the opening arguments. I don't know how.
I'm going to stop this at 31 seconds and just briefly.
I wish I could find the opening arguments.
An individual driving the car. Was that you driving the car?
Yes, sir.
Now, this driving the car, was this what you previously testified to about driving 300, 400 feet, whatever it was?
Yes, sir.
To the location?
Correct.
Now, in this pause screen here, can we actually see that same bridge?
Yes, sir.
Is that kind of just, I have a pointer somewhere. Thank you. Is that this location right here?
That is correct. Austin Powder Springs Road.
Now, who is this in front of you?
That is Sergeant Hayes.
Now, is Sergeant Hayes with you through your search?
Yes, sir.
All right. I'm going to proceed with State's Exhibit 10.
Right.
Now, pausing once again at 1 minute. Now, where I have it paused here, you sort of saw like an embankment kind of downhill right here in the video.
Yes, sir.
Is that where the car was?
Yes.
All right. And so where you're about to walk, was that where the burnt car was before it was being removed?
Yes.
Proceeding with State's Exhibit 10.
Anything? Trash? Anything?
So she was a roller skating influencer. You're funny. We're killer sideburns.
Hey, is anything?
Darn it. And
I'm looking over this way.
oh my gosh. So
Okay.
holy moly.
Nothing over in there.
81
even a walk
times.
path
He
where
stabby stabbed her
somebody has
81
come through here.
times. And then set her on fire.
Wow.
Holy moly.
Yep. Backed up. Oh.
I'm gonna stop it at 5 minutes and 57 seconds. Now, for the jury, can you kind of describe this kind of area? Was this a frequented area by a lot of people?
No, sir.
No, we do see some items throughout the woods. Was there trash kind of littered throughout?
Yes, sir.
Now, as you kind of walked through, were you able to kind of determine whether trash was old or new or anything like that?
No.
Based off of kind of weathering of any of these items, could you determine whether or not they were
Darn it. I'm not gonna do this. Okay, this is her. the heck? I want to have both things on the screen.
Huh? Yeah.
Oh, we got the car.
Yep.
No. This is annoying.
Direct the jurors to attention here. Stopping the video at 6 minutes and 49 seconds. Here, in front of Sergeant Hayes, what do we see right here? Sorry, I know you can't really see from our end. These items here.
Oh, our patrol cars.
Okay.
Yes.
All right. And so, and is that where both of y'all's patrol cars are parked?
Yes, sir.
All right. And you have a seat.
Okay.
Now, resuming the video. I know you have the screen in front of you. What just happened?
This is when we located the female body.
Now, are the jurors kind of looking toward that logish, kind of that larger log in the middle?
Yes, sir.
Now, at what time is Sergeant Hayes, I guess, putting this notification out?
I want to say, 1441.
And for those non-military people?
That's
Come in between the back of yours and in front of my truck. We got a 48 female. Radio, make sure detectives are aware of that.
This, for the jurors, I'm pausing it once again, and I apologize. If you can kind of step toward me.
Yes.
Sort of. Now, in this area here, where in particular are we looking, and where is the body located?
right here.
Okay, so that tree log, is that?
Yes, sir. The body is right here on the other side of the tree log.
Now, with the cars, how close is the body from the cars?
Oof. At least 100 feet, if that.
Okay. Now, from those cars that we can see kind of through the trees here, could the body be seen?
No, sir.
And what prevented you from being able to see the body from where you parked your car?
All of the brush, trees, the lawns.
All right, perfect. Have a seat for me. Now resuming the video at 7 minutes and 28 seconds.
Go see if you got crime scene tape.
Yes.
Go get it.
Okay. Want to get crime scene tape?
Yeah, that's insane.
I'm going to my car now.
We got it. I'm sorry. Look it up.
Oh my God. He was only 22. So she was a little Instagram person. She was a roller skater chick.
Got it. Yes, sir.
So they didn't show the opening statements. This is the detective on the scene, officer on the scene, where they found the burning.
Okay, we backing up? Okay.
Right where your car was, behind mine, it's right there again, directly into the line. Radio self bucket, come down Road Jordan, past Lander Street, keep going till you see the power lines.
Now this is an interesting trial. You would think is cut and dry. So I'm gonna watch this while we're on lunch.
How about right here, Alex?
Tie it to my truck.
Your truck?
And then
Yes. I don't mind. Okay. All right. Go ahead and drop it. Let me,
it's just so hot out. I don't want nothing igniting.
Right.
In the loft.
No, we definitely make sure. Hey, grab it. Just grab the water can just in case. We'll keep on standby. Yep.
No, pausing the video at 12:44. See a cell phone. Is that your cell phone?
That's the work cell phone, yes, sir.
And so you seem to be taking a picture of something and you reference the citation. Is that what we're talking about?
Yes, that's the citation laying on the ground.
And were you just kind of taking a preliminary photograph of it?
Yes, sir. Everything in the area.
Well, I apologize. I messed up.
Yep.
And then from where can we see that citation kind of right there at the bottom?
Yes, sir.
And do we see that same log that we pointed out earlier?
Correct, yes.
And then behind that log, what are we seeing?
The dead body of a female.
And we see a lot of sticks and stuff. Is that what you kind of mentioned that she was being covered with?
Yes, sir.
And No, from, I mean, from Austell Bridge, could you see this?
No.
From the Austell Bridge, what was the only thing that could be seen of this entire 2 locations of the car and this body?
Probably just the smoke and fire coming from the car.
From that road, could you even tell that it was a car that was on fire or that the wood
No,
was on
sir.
fire?
Mm-mm.
Okay. We'll proceed with the video.
This is very recent. Because all this is dry. And that's the only thing that's burning.
Anyone want to from that? That's your
Yes, sir.
Anxiety radio. When you're not finished, start time machine. All right, in the middle of the
I'm stopping the video at 13 minutes and 20 seconds. So at this point, has, I guess, supervisors and I guess dispatch been notified of this, this body?
Yes, sir.
And at what point do detectives get involved?
Very shortly. The detective has been called. He's actually en route at this time.
All right. And at what point does the medical examiner's office or the coroner's office get involved?
Just a little bit later, I would say within the next 10 to 15 minutes.
In your experience, would the coroner's office and the medical examiner's office, they have their own type of trucks and vehicles?
Yes, sir.
And are those labeled vehicles just like cop cars?
Yes, sir.
However, with, I guess, medical examiner's office on it?
Correct.
All right. And at this time, at the end of this video, what time is it based off the body count?
14:47, that's 2:47 p.m.
Let me ask you just kind of a clarification question. When dispatch is notified of a situation like this, you indicated that the ME's office or the coroners would be notified within 15 minutes or so?
Not necessarily 15 minutes. They'll probably arrive. They said they were on their way.
Okay.
They had been called dispatch just as the detectives and everyone else.
And so how much longer did you stay on the scene?
Several hours.
All right. And did you, what was the purpose of you staying on the scene?
So after I left this immediate scene, I was asked to begin a crime log and begin logging everyone that literally came to that scene at that time. And then I was asked to push to the perimeter because news media had been informed and we wanted to kind of preserve the area. So I maintained the area, keeping anyone from coming in there except for law enforcement and emergency vehicles.
Now, based off of that, you're kind of having some understanding as to who is coming and going. About how long did it take for detectives to kind of arrive here?
Say within, the call went out, he was there within 3 to 5 minutes, if that.
And then what about the medical examiners and coroners, if you remember?
Off the top of my head, maybe another 10, 15 minutes, somewhere in there.
Outside of that, any additional involvement in this case?
No, sir.
Nothing further. Thank you so much.
Thank you, sir.
Your witness.
Officer Harris, I didn't get your, I know it's not your rank now, at the time, would you be officer, detective, what would we call it?
Patrol officer.
Patrol officer, okay. If I just call you Officer Harris, would that be okay?
That'll be fine, sir.
Or Mr. Harris, maybe better.
Yes, sir. That's fine.
With the DA's office. So as y'all were walking through the brush area, this is August. It's a typical, very hot, sweaty sort of day being out there looking at this area. Is that correct?
Correct.
And as y'all drove up the area from the road, driving down all the way down to this, where the car was, you indicated 400 or 500 feet. Is that a paved, well, there's not a paved road there, correct?
Correct.
Is there a gravel road or something that looks like it's gonna cut out as a road at all in that area?
It's a grass road.
Okay. So it's like,
Grass area.
It's a field. Right?
Yes, correct.
And there's power lines that go through it, so it's kind of clear where the power lines come through. That's why you've got the wooded area around it. Is that right?
Correct.
Okay. And so as y'all got out of your cars, going back to look to see if you can find something, were you looking to see if you could see some indication of a path or a direction of travel somebody might have gone from that car?
Yes, sir.
Because your purpose was to see if you could find Miss Beauty Couch, who was now missing.
Correct.
And you didn't see anything obvious to you as you were looking around there as to a path someone may have already taken.
Correct.
And I think as you're following with FTO Hayes, that you make a comment where there's not even a walk path, suggesting maybe some recently moved brush or something in case somebody just walked through there.
Not in the area we were at the time. Correct.
And so the closest distance between where the body was found and where your cars were, behind where the burned car would have been, you did not see any indication of some knockdown brush or anything to indicate someone had recently been in that area.
No, sir.
At some point in time, as you're going out there looking, were you looking for maybe any indication of blood or other items that might be indicative of where Miss Couch would have been?
At that time, we were just simply looking for Miss Beauty Couch or anyone pertaining to that vehicle.
Sure.
Thought they may have been walking or something.
Gotcha. Okay. And I think we see a little bit in the video there, after y'all have found the body and you go back to get the crime scene tape, you take a more direct route through the brush to get to your car.
Correct.
And that's maybe hilly is not the right word, but it's not level terrain getting through there, correct?
Correct.
And you smartly put on your gloves to kind of keep yourself from getting scraped and scratched, getting through all that stuff.
Correct.
Did you take part in doing any further searching in that area to see if there was any blood evidence or other indication of a direction of travel?
No, sir.
Well, the bottom line is you certainly didn't see any from your vantage point as you were looking at it that day.
Correct.
Did you see anything at all that indicated to you something heavy had been dragged through the ground?
No, sir. Couldn't tell at that time.
And other than the area where the car had been and was burned, and then where you ultimately found the body, in between those two areas, any indication of any sort of burned items or anything of that?
No, sir.
Do you recall anything suggesting, well, did you even smell anything that smelled like gasoline as you were on the scene that day?
No, sir.
And so as you were walking around the area, you didn't smell that anywhere else either, you would have noted that?
No, sir.
All right. And if I understand correctly, you didn't take part in any of the recovery of the body or removal of the body that day?
Correct, sir.
All right. And you said you were out there for several hours. Were you one of the officers that went to Ms. Thurman's house and spoke to her initially?
Yes.
Is that right?
Uh-huh.
And at the point in time that you indicated, or you had been informed from Ms. Thurman about there being a boyfriend involved, did that cause you any concern or thinking about this investigation as to which direction it might go?
No, sir.
At that point in time, you don't really know anything other than we got Beauty missing.
Correct.
Do you recall on the scene not long after y'all have found the body and looking at this looking at the citation, do you recall being able to get a name of a person off the citation?
No, sir.
And you didn't take part in the cover and get it all, you just.
No, sir.
You saw it and left. Do you recall at what point in time you began being part of the discussion with FTO Hayes and maybe others about the suspect in this case?
I do not.
You don't recall that happening soon thereafter as y'all were back up near the road, there on the location?
Answer, give me your question again.
Sure. Trying to, a point in time in which there's discussion had that you were a part of specifically of there being a suspect in this case.
No suspect, because we were just informed that she was probably with her boyfriend or what have you. But yeah, his name was mentioned, but not a suspect at the time.
You recall telling, let's see. Your body camera continued to function that day, correct?
Yes, sir.
And beyond this video, there are other videos that capture different periods of time that y'all are doing your work down that day, correct?
Correct.
And you recall at some point in time, you and FTO Hayes talking about having found the body and FTO Hayes having been involved with the second body that had been found in Austell that year. Does that ring a bell at all with you?
I don't recall that.
And do you indicate at all some discussion about having a possible suspect and then a name of a suspect? Does that come to your mind at all?
Don't recall at this time, no, sir.
And after you finished that day, I take it you didn't have any further specific obligations in this investigation?
No, sir. It was turned over to COP.
All right. Thank you very much.
Yes, sir. Thank you.
Nothing further.
May this witness be excused?
Yes, sir.
Anything from you, Mr. Lumpkin?
No objection.
All right, you are excused, released from your subpoena. Please watch your head as you step down.
Thank you, Your Honor.
And call your next witness.
State calls Anastasia Kendrick.
Counsel, Mr. Hurwitz, can we move
Yes.
the monitor back? I just don't want somebody to hit their head. You got it, Amy? Thank you. Come on up, please. To the bailiff right here, and she'll show you where to go on the witness stand, okay? No, ma'am, that's okay. You're gonna come around with her.
You do solemnly swear or affirm the testimony you're about to give before the matter of opinion shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
You can actually pull it closer to you. The whole thing moves. There you go. Thank you.
There we go. If you will, please introduce yourself to the jurors and spell both your first and last name for the court reporter.
My name is Antonasia, Antonasia. Last name Kendrick, Kendrick.
Very good. And how old are you, Ms. Kendrick?
I am 25 years old.
Are you from Georgia?
Yes.
What do you do for a living?
I'm a personal injury paralegal.
And how long have you been doing that?
For the past 3.5 years.
Very good. I want to talk to you about some relationships. Did you know Beauty Couch?
Yes.
And how did you know her?
She was my friend.
When did you first meet?
We met in 2020.
How did you meet her?
We met through a mutual friend at a photo shoot.
Now, had you seen her around prior to 2020?
Yeah, we hung out regularly, like often.
Well, in other words, before the photo shoot where you really got to know her, did you know of her prior to that?
Yeah, we also went to the same high school, so we had like mutual friends and stuff.
Okay. When y'all were in high school, were you super close?
No.
Okay. Was it once you kind of met through this mutual friend that you all became closer?
Yes.
Once you kind of formally met through this mutual friend, how close were y'all?
We became really close. Like my first day meeting her, she was like amazing. Like she just became one of my closest friends, actually.
Did y'all talk most days?
Yeah, we talked often.
Did you hang out regularly as well?
Yeah, we hung out often.
And when y'all talked regularly, if you weren't physically together, how did you communicate?
Like on the phone, text message, social media, FaceTime.
Was she relatively active on her phone?
From my knowledge, yes.
In other words, sometimes we have those friends and you text them and they might not respond for a couple days or something like
No,
that.
she wasn't like that. Most of the time, like if we talked, we would talk. I would hear from her by the end of the day. Like if I called her, she didn't answer, I would hear from her by the end of the day.
Did you all ever work together?
Yes, we worked at a lounge together. It used to be called Blazing. I think it's called like Sunset or Sunrise now or something. It's off of Maxim Road.
Off of Maxim Road?
Mm-hmm.
And what city is that in?
I believe it's Austell.
I also want to talk to you about Eugene Jacques. Do you know Eugene Jacques?
I knew of him through Beauty.
Is that how you met him?
Yes.
What year was that when you first met Eugene?
2023.
And is that what you called him, Eugene?
Yeah.
Do you know how Beauty and Eugene initially met?
Beauty told me that they met at some convention. I think it was called Skate Jam, I believe.
Were they both involved in kind of the skating industry or world?
Beauty was definitely active in the skate world. I'm not sure if he was like active in the skate world or if he was just at the event.
I gotcha. Now, when you met Eugene, where was he living?
When he first was introduced to me by Beauty, like the idea of him, I never physically met him, but he was in Florida originally.
Did he later move to Georgia?
Maybe like a month of them, maybe not even a month and a half, 2 months later, yeah, he moved to Georgia.
Once he moved to Georgia, did you meet him in person?
Yeah, I met him because he would come to like our job and like sit there.
Is that the Blazing Lounge?
Yeah.
You said he would come to your job and sit there. Can you talk to us a little bit more about that?
We worked at a lounge, so it was like a nighttime thing. So we would be there probably from like 8 to like maybe 1, 2 in the morning, sometimes 7, just depend. And he would like sit through the shift and be there.
Was that like with friends with him or?
No, by himself. Sometimes he would sit in the car and wait outside.
Did your relationship with Beauty change at all once she was dating Eugene?
I would say Beauty herself never changed, but like I'm a very spontaneous person. So I was like the friend, like I would call the same day, hey, let's go somewhere. And, Beauty would be like, okay, if she's not busy. So it kind of changed in that aspect. Like I would call and it would be like, oh, I have to ask my boyfriend or I have to see, what we're doing and things of that nature. So she kind of got more distant in the things like that we normally would do.
I want to talk to you about August 21st going into August 22nd of 2023. Do you remember those days?
Yes.
Starting on August 21st of 2023, do you recall whether you had any communications with Beauty on that day?
Yes.
What sparked the two of you communicating on August 21st?
Well, I'd seen Beauty maybe like a week prior. We hadn't really talked, but she had posted some stuff on Instagram that was kind of alarming to me. So I reached out to her.
And when you reached out to her, was that on August 21st or is that a different day? Do you recall?
That was on August 21st. It was like nighttime, like right before I went to sleep.
All right, at this time, the state would move to tender State's Exhibit 43, which is the Instagram business record certificate for Beauty Couch's Instagram, as well as States 44, 45, and 46, which are stories from this Instagram page covered by the business record certificate.
We'll have an objection to that. We want to speak to that briefly once that presence.
All right, ladies and gentlemen, I'm going to ask you to step to the back for a moment, please, while the lawyers and I handle this legal issue. All right, Mr. Lumpkin, tell me about your objection.
Yes, ma'am. I understand that these are records that have been provided through Instagram, pursuant to a subpoena, and there may very well be a sufficient foundation as to that, as to where they come from. My objection is going to be is any attempt to have this witness speak to them or interpret them or address them and try to characterize them in a way other than these are simply records. We don't know exactly who posted these and where they came. We just know they were on this particular account. Having a disagreement with that. But to the extent that the only purpose I know of doing this is with this witness here is to attempt to have them provide some characterization of that. I don't think that's appropriate. And to the extent there may be some attempt to gain further hearsay of Ms. Couch to this witness, I don't think there's a sufficient foundation laid for that to be done at this point in time.
So, Your Honor, these, I think it would be helpful. May I pass them to the court?
Oh, Your Honor.
I'm going to pass Your Honor States 44, 45, and 46, just so you can see exactly what these posts are. These are stories that were posted on Beauty's Instagram page, and as the witness referenced, she saw some of the postings which caused Antonasia to then reach out to Beauty. We're not going to go into the content of what Beauty said in response to Antonasia reaching out to her, but as this witness has testified, that the Instagram posts are what caused Antonasia to reach out because she was alarmed or felt like something could be going on. Your Honor, I think at the end of the day, these go towards two primary things. Number one is establishing the timeline that we're looking at as to signs of life and activity coming from Beauty Couch's phone or social media pages. So timeline is going to be important, which is not offering these statements or posts for the truth of the matter asserted, but rather going to the timeline. And then number two
is not whether these statements are true, not saying that we're proving what she wrote is a true statement or accurate or material or anything else, but rather the effect that it had on this witness in her decision to reach out to Beauty on these occasions to see what was going on. So State versus Gates. I'm sorry, Gates versus State. That is 298 Georgia 324. I believe that's a 2016 case. And in that case, it talks about for a statement to constitute hearsay, it must be offered in evidence to prove the truth of the matter asserted. In that particular case, there was a text message sent essentially saying, if you're lonely, you can call me, along with some sort of naked picture. The case goes on to say that it wasn't offered to prove whether in fact someone could call this person if they were lonely. Rather, it went to the effect on a particular individual and his motive for committing a murder. So I think this is similar in nature to that case, where we're not trying to prove whether or not the statements she made in these texts are true, but rather the effect on the effect on Antonasia, as well as establishing this timeline.
Anything else, Mr. Lumpkin?
Yes, Your Honor. One, as far as the timeline goes, and I'll not able to look at it again. I'm looking for a timing, something indicates.
There's a timestamp at the top. There's a timestamp.
There's some information there, but that doesn't tell us that's when it was posted. It doesn't provide us any sort of time other than, at least at that time, it had to have been then or before that it was posted. To the extent the state's going to try to characterize that as actually when it was posted, the certification doesn't indicate that I can see. We just had timestamps, and I see them all the time where I get anecdotally on others on Instagram getting posted well after they have been posted. That's when I see them, and that's indicated on my phone to get them. So
I think if we can just be clear on whether it is a post or a story.
It's a story, so it has
which are
a
different.
story ID with the timestamp posted, and then that comes from the Instagram records themselves, not from like a screenshot of that story or anything.
where's the certification?
Right here.
It doesn't, it doesn't answer that question, but I can tell, what
Go ahead.
the second issue has to, she's already testified that she saw some posts and it caused her to reach out. If that's all they're trying to get at, we've already got that. She had a reaction, she's reached out. They're not going into any hearsay beyond that, and that's my main objection, frankly. So it's not like maybe that issue's been covered. She's not going to address anything that she said or try to characterize what any of these things meant based on that conversation. So as long as that's the case, I don't have a problem with that. But again, I'm just going to object as to the nature of these without, as I object, I don't think they lay out a specific timeline upon which we can trust they meet what the state is attempting to argue.
So whether or not it establishes a timeline or doesn't establish a timeline, I believe that what I heard when the state said that was this was why it's relevant. This was kind of what the purpose was, as opposed to the truth of the matter asserted. I do think a proper foundation has been laid. To the extent there are objections going forward to certain questions that are asked of this witness, I mean, you're just going to have to, we'll just have to see how the testimony goes. Like, I'm not sure right now, the objection to these documents being admitted into evidence is overruled. I am not ruling on any individual question. I am ruling on the objection to these documents being admitted in evidence. So anything before we bring our jury back in?
I appreciate that, and I recognize there's an ongoing issue. It just seemed like the best time to do it, so we do it at one time if we're able to. Based on what I'm hearing the state say, it sounds like we may not have another issue, but I'm hearing the court say if there is, then feel free.
Didn't stand up. I'm not making a blanket ruling on anything that the state asks of this witness is appropriate. Like I'm not really sure what the state's going to ask. My crystal ball's not working all that well right this second. So anything else before we bring the jury back in? All right, bring them back in. All right, ladies and gentlemen, please have a seat. Before I excuse the jury, there was an objection to State's Exhibit 43, 44, 45, and 46. That objections overrule, and those documents are admitted over objection. You may proceed.
Thank you, Your Honor. May I publish?
You may.
All right, so Antonasia, looking at State's Exhibit 44 here, is this one of the posts that caused you concern?
Yes.
Looking at State's 45, is this another one of the posts that caused you concern?
Yes.
Now, when you were concerned, did you reach out to her?
Yes.
Do you recall in what manner you reached out to her?
I was just checking on her.
Well, in other words, phone call, text message.
Oh, I texted her on Instagram first because that's where the posts were posted. That was like around 9 p.m.
Around 9 p.m. you said?
Yeah. I went to sleep. I have a sleep disorder, so I fall asleep sometimes. So I went to sleep like probably briefly after that. She texted me around 10.
Okay, we're not going to go into what she said, but so she texted you.
Yes.
She responded.
Yes.
And was that through Instagram
no,
or
that was
separate?
through text message.
Okay.
And then when I woke up, it was around maybe like 1 or 2 a.m. on the 23rd of August. I texted her back.
And was that a regular text message?
Yes. So then she posted on Instagram again on the 23rd in the morning. So like, I kind of, okay, she'll get back to me later on that day. Never heard from her. I called her. She never answered.
And so you mentioned that she posted again the next day, looking at State's 46 here. Is this the post you saw the next day?
Yes, one of them.
And do you recall what time it was when this post was made?
This one was after.
She said the first knowledge of when it was made, she testified when she saw it.
Fair enough. Do you remember when you saw it?
Okay.
You said you woke up around 1 or 2 a.m. and then she posted later in the morning.
Yes.
On the question, when she posted, all we know is when someone saw something. Be very clear. So they
I agree.
can testify to it for her.
I agree when she saw it.
Okay, I first saw her first post. It had a timestamp of 6 o'clock in the morning. It was a broadcast, which is something that people like send out when they have like a following and they want to keep.
Injection, speculation, what people do. That's how what she saw. I don't have a problem.
You can lay a foundation for that. Okay. So you mentioned a broadcast. Without talking about why someone might use a broadcast, what is a broadcast on Instagram?
It's like a channel with multiple people in it.
Okay.
Like for whatever people may want to post in there.
Okay,
It's
so
specifically for like their followers.
and that, it sounds like that's different from a story.
Yeah, it's not a story.
Okay.
It's almost like a group chat. That's the best way, like a big group chat for your following.
And is that kind of like a live thing, or is that?
The best way I could describe it is like a group chat. Like you
Okay.
send out a message and it'll be there. Like it's like a text message, but to your followers.
Okay, so similar to direct messaging on Instagram,
Yeah.
but to a specific group.
Mm-hmm.
Okay. And so you said there was a broadcast around 6 a.m.
Mm-hmm.
All right, and then after that, was there any other post?
The story.
And is that what we're looking at in States 46?
Yes.
Do you remember when you saw States 46?
I want to say like I personally saw it like midday, so a little after it was posted.
Did you reach out to her after this post?
That's when I called, like around the time when I called her, because I thought it was strange. She wasn't responding and she texted me the night prior.
And when you called her, do you recall whether the phone actually rang?
It was a FaceTime call.
Okay. But in other words, did it go through?
No.
So normally with FaceTime, it makes kind of that special sound as opposed to a ringing. Did it do that at all, or did it immediately just say this person's not available for FaceTime? Do you remember?
I don't remember.
That's okay. What we're looking at with States 46, was there any further posts from her account that you ever saw?
Not that I ever seen.
Give me just a moment. Now, you mentioned the purpose of you reaching out was kind of to check on her. You'd say yes and no.
Oh, yes, sorry.
Without going into what she said in response, did you get any clarification for yourself?
No.
That's all I have. Thank you.
You're right, Mr. Malkin.
Thank you. Good morning, Ms. Kendrick. I think the first person to kind of talk to a little bit more, so I'm going to ask you a couple of questions. If you don't know the answer, certainly just let us know. If you do, please let us know what you can. You said that Beauty was active in the skate world. Tell us what you mean by that.
Well, she had a following because she skated.
When you say she skated, what do you mean by that?
Roller skated.
Okay. And she had a following because she roller skated?
She was a good skater, so people enjoyed her energy. They enjoyed watching her. They enjoyed seeing her. So, I mean, that attracts people. People like to see good content, good people.
Okay. When you refer to content, are you referring to stuff placed on social media as opposed to just skating at a roller rink?
Yes, like videos.
All right. Did she do that actively?
She was an influencer, so she did it consistently.
Okay. And when you say influencer, we may all know what that means, but I just want to make sure I understand what you mean by that. What do you mean by that?
She posted on social media. often because that was something she enjoyed doing.
And were you part of the followers that would watch her information, look at it, and enjoy it?
Yes, we followed each other.
Were you active in the skating community yourself?
I mean, we started skating together. I just didn't enjoy it as much as she did. So she continued with it. I did not.
Do you have any idea about how many followers she had? Do you have any way of knowing that?
She had over 100,000 followers.
And you know that because that's posted on the site that you were looking at?
I know that because I followed her, and as she grew, like I always made sure I congratulated her on her accomplishments.
And did she win some awards, that sort of thing, in the roller skating world?
I don't know about any awards.
Okay. You said you were congratulating her on
Yeah, like achieving milestones like 50K, 100K, like those are milestones, things that she wanted to achieve for her.
Are you saying that she skated 50,000 miles? Is that what
50,000
50K?
followers,
Oh,
100,000 followers.
I
Those
got
are
you.
milestones.
All right. And how long had you been following her?
Since we became friends, at least since 2020.
Okay. So she had this social media following since 2020?
No, so like I said, she was growing. So from the time I met her, she had, of course, less followers. She grew as a content creator.
And did you meet her at a skating event?
No, once again, I met her at a photo shoot through a mutual friend.
That's right, a photo shoot. Gotcha. Was that a photo shoot for the roller skating world?
No, it was a photo shoot for my clothing brand.
All right. And then y'all worked at this lounge starting in June. Is that, did I get that right?
We started in May.
In May. All right. Very good. Okay. I think that's all the questions I have. Thank you.
I don't have anything further. Thank you. May this witness be excused? Yes, please.
No objection.
All right, you are excused and released from your subpoena. Call your next witness. We're going to continue until our lunch is ready to make best use of our time.
At this time, the state calls Detective Michael Lincoln.
And by our lunch, I mean your lunch.
I do.
Good morning. Morning. If you'll please introduce yourself to the jury and spell your name for the court reporter.
Sure. I am Detective Michael Lincoln with the Cobb County Police Department.
Can you pull that microphone a little closer, please? Thank you.
Sure. Detective Lincoln with the Cobb County Police Department with the Crimes Against Persons Unit. My name is spelled M-I-C-H-A-E-L, last name L-I-N-C-O-L-N.
Now, you've mentioned the Crimes Against Persons Unit. What is that?
That is a unit within the Major Crimes Division. We investigate primarily homicides, robberies, aggravated assaults, things of that nature.
And how long have you been with the Crimes Against Persons?
I've been with Crimes Against Persons about 6 years now, 5.5 years.
Right. And that is that Crime Against Persons Unit within the Cobb County Police Department?
Yes, it is.
Now, prior to going to the Crimes Against Persons Unit and Cobb County Police Department, did you have prior law enforcement experience?
Yes, I actually started my law enforcement career in Columbus, Georgia, in 2014. Then I came to Cobb County in 2017.
So working with the Columbus Police Department, were you post-certified back then?
Yes, I was.
Have you been post-certified since 2014?
Yes, sir.
Now, for the jurors, kind of give them an understanding of how the Crimes Against Persons Unit kind of works together.
Sure. So whenever a major case comes in, murder, especially one where the suspect is not on scene, for example, we'll have multiple detectives who work it. So one will be assigned as what we call the lead or the one. The one will be assigned as number two, so secondary to the lead. But all sorts of detectives will come in and work it. The reason being is there's multiple different things to do. There's people to interview, there's a crime scene to go to. There could be having to go to the hospital, different things like that, search warrants to get. So it's a very collaborative effort.
Is there a lot of moving parts when it comes to homicide investigation?
Yes.
All right. Now, back on August the 23rd, 2023, were you working in the capacity as a Crimes Against Persons detective?
Yes, I was.
Were you on duty that day?
Yes, sir.
All right. Did you respond to a homicide investigation that occurred along the power lines of near Joe Jerkins?
Yes, I did.
And did you actually respond to that location?
I got there eventually. I initially responded to Austell PD headquarters.
And that actually leads me to my next question. So we heard that Austell originally responded. Why is it that Cobb County then comes in and helps in the investigation?
So Austell Police Department is a pretty small department with limited funding, limited resources. So we work the majority, if not all, of their murders or homicides.
So is it just more of a manpower issue?
Yes, sir.
All right. Now, that area where Joe Jerkins, I understand that you got there eventually. Is that here in Cobb County?
Yes, it is.
Now, for the jurors, can you kind of explain that notification process of Austell to Cobb County?
Sure. So we got a phone call. I believe Sergeant Murphy was the one who took it at around 15:30 hours, so around 3:30 p.m. Basically saying that they had located a body which appeared to be burned in the woods. And then they informed us they had previously responded out to that same location, the power lines out there, for a car fire. They located a vehicle that was completely engulfed, eventually got it put out, and then had it towed to a record yard. Once they were at the record yard, they ran the VIN on the vehicle once they were able to identify one, and it came back to a lady named Deanna Thurman, who lived about 1 minute away from there. So they went to her house, and she informed them that her daughter Beauty Couch had been missing for about a day. At that point, they realized that they were kind of in over their heads, not to talk down about them, but like I said, they just had limited resources. So they reached out to us.
And so with reaching out to you, I think you previously mentioned that you actually responded to the Austell Police Department.
Yes, sir.
Why did you respond to the Austell Police Department?
I went there to interview Deanna Thurman as well as one of Beauty Couch's friends, Jakari Smalls.
What was the purpose of interviewing Deanna Thurman and Jakari Small?
To gather more information about Beauty as a person, her habits, if she had any enemies, anything like that, just to get an overall picture of her day-to-day life and things like that.
Was that an attempt to try to locate her as well?
Yes, sir. At that point, we weren't yet certain that the person in the woods was her. We obviously believed it likely was. But if there was anything we could do to rule that out and actually find her alive, that would be another purpose for the interview as well.
And were you able to identify as the woman in the woods as Beauty Couch?
Yes, after speaking with them, I made a phone call to Detective Hardage, and he informed me that he had been able to positively identify Beauty Couch.
Now, were you able to conduct those interviews with Deanna Thurman and Jakari Smalls?
Yes, I was.
Now, after completing those interviews, what did you do next?
So after completing the interviews and notifying them that we had in fact identified Beauty Couch, I asked for permission to go to Deanna Thurman's house where Beauty lived with her and look around in the bedroom, in Beauty's bedroom specifically. So we drove there and did that.
Now, did you find anything of interest within Beauty's room or the home?
Not really. We did find 2 cell phone cases we took photos of because they had the IMEI. So just in case we weren't able to develop any more leads, we had that as a backup.
Now, you just mentioned 2 things, two cell phone cases. Did you actually find those cell phones?
No, sir.
Now, IMEI, what is that?
That's an identifying number. It just basically identifies that particular device.
Is it kind of like a serial number for a phone?
Yes, sir.
All right. And ultimately, those phones were never located?
No, sir, not to my knowledge.
All right. Now, in reviewing her room, did you have to go through the house as well to get to her room?
Part of it, when you enter the home, you're in a living room, and then her room was directly to the right. So we entered a small portion of the home.
Now, was anything jumping out at you when you were conducting that search?
No, her room was extremely orderly, neat, clean. The house overall was neat and clean. There were no signs of, physical struggle inside. No couches knocked over, no broken glass, no forced entry on the door, nothing like that.
Once you completed the search of Beauty's home, what did you do next?
After completing the search of her home, I responded to the crime scene where other detectives had initially responded to.
Now, when you got on scene, were crime scene techs on scene?
Yes, sir.
Were Austell police on scene?
Yes, sir.
Were other crimes against persons detectives on scene?
Yes, sir.
Was Detective McCulloch on scene?
Yes, sir.
Was the medical examiner and coroner on scene?
Yes.
All right. So at this time, when you arrived, was the scene preserved?
Yes, sir.
All right. Kind of describe to the jurors as the role of a crime scene tech with a detective.
So a crime scene tech, they work kind of hand in hand with the lead detective. So when you get to a scene, obviously by the time we get there, it's already some time has passed, even if it hadn't been the thing with Austell. By the time we get there, patrol officers have been there and they've secured the scene, typically with crime scene tape, which was the case this time. So they will walk with the detective, go over the scene, try to get an overall picture, identify items of evidence. The detective will tell them which items of evidence he wants collected, which ones can just be photographed, etc. They'll then photograph the scene as a whole, and then they'll take medium range and then close-up range photographs of the actual items of evidentiary value. And the reason for the different types of photos is to try and give context to the scene. For example, if it was an outdoor scene, you need to give some perspective as to the distance, say somebody ran or something like that. If there was a blood trail, you need to give perspective to that. So that's the reason for that. Once those photographs are taken, they will lay down crime scene markers, marking each item of evidence with a specific identifying number. And then they will redo the medium and close range photographs of those items specifically. And then they will collect the items and document the time at which they were collected. And then oftentimes on murders, they will also do a video, which is again to help with the perspective of the size of a scene or just the layout of a home, for example. It can be hard to capture that with just photographs. And then sometimes they will also do actual scans. There's a machine called a Faro. It's the easiest way to describe what it looks like is if you've ever gone on Zillow and you see where you can look at the houses and you can actually kind of walk through them. It essentially creates that, but for the scene.
Wonderful. So in this case, were crime scene photos taken?
Yes, sir.
And that video of the kind of the scenes, was that done in this case?
Yes, it was.
Now, we'll hear about the crime scene in further detail through Detective McCulloch, but prior to testifying, or did we meet?
Yes, sir.
Did we go over the crime scene videos that were taken at this scene?
Yes, sir, we did.
And were those videos fair and accurate recordings of the scene as you observed it that day?
Yes, sir, they were.
At this time, the state moves to enter what's marked as State's Exhibit 47.
Objection?
This is that very video you were just talking about.
Yeah, the crime scene videos.
No objection. But when we say crime scene video, we're talking about the area out of woods. Objection.
All right, so case 47 be admitted without objection.
All right, at this time, the state is publishing State's Exhibit 47, Video 1. Oh. Okay. Now, just to orient the jurors at the beginning of this video, where the video is being recorded, is this kind of like the outset of where the power line kind of opening would be?
The opening into the wooded area, you mean?
Like, yeah, you were standing in like in the easement, I guess.
Yes, sir. If you're standing along the power lines facing the woods where the victim was located, that's what you're seeing right now.
Is this, how many videos were taken of this scene?
2.
And was this video that we are looking at here, video 1, focused on where the body was located?
Yes, sir.
And is the second video focused on where the car was located?
Yes, sir.
Pausing the video here at 1 minute and 24 seconds. What is the camera focusing in on here?
So that is either a wig or a piece of weave that was near the body of the victim.
ultimately, well, what are we seeing here at 4 minutes and 27 seconds?
So that is a citation, or it looks like possibly a payment form for a citation for a vehicle out of Florida. And it was from earlier in the year.
I know I did a bad job at. Can you see it in front of you?
Yes, sir.
Are you able to read the citation number off of it?
Yes, sir. It's 27 D as in Delta, D as in Delta, JC. And it's out of Florida.
And that's the license plate, right?
Yes, sir.
And then the citation number above it?
That is A202814. I believe that's another one. It's obstructed by the leaf. And then 10.
Now, ultimately, and we'll hear about this later, but to your understanding, was this collective?
Yes, sir.
Sorry. Oh, wait.
It's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
Oh, he's a parent. This is one of the parents.
It can end here, but again,
I don't know which
I'll
parent.
let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Your Honor, I might agree with Mr. Jenkins if the Commonwealth had to prove some type of serious injury, but that's not what is charged. It's felony abuse and neglect, but it's not based on any injury. It's based on my conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay. Do you need the attorney to repeat his question?
Yes, please.
Okay. How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If you
have to answer the question
Yeah.
that he asked.
Okay.
Yeah.
So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room, being confined to an area, having, I don't know how much light it was, but he's scared of the dark,
having added more light and going to therapy.
Okay. And were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions for you.
And now they're just bringing in parents of students who were affected by this incident, which is kind of messed up because now this is the emotional part that's going to make the jury. This isn't a factual.
Good afternoon, Mr. Garcia. I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Rich Neck, correct?
Correct.
So he was not in Ms. Werner's classroom, correct? Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the police.
Oh, well, I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2023, correct?
Correct.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No, I didn't. You have
But-
to talk to my attorney.
I'm sorry?
You have to talk to my attorney on that.
Okay.
Dang, these people got attitude.
You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not going to talk about that on camera because it's streaming.
Judge, I am going to make a limited objection here in that any civil suits relate to the children. And I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child. And I support that request and ask the court to do that.
Response?
Well, Your Honor, he just asked a series of questions about the child on a camera. I'm asking about a civil case, asking him whether he filed a civil case. It has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes.
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
Okay. So you have a financial interest in the outcome of this criminal trial?
Financial, what do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes.
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
Possibly, yes.
Okay.
Why are they suing her specifically, though? I mean, I understand the school, maybe, kind of, sort of, but.
When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay. So 10 days after the shooting occurred. Okay. And how did you get that notification?
I was called by the city, the Newport News Public Schools, I forgot the name of the downtown director of people, but I know her name, but she called me at 6 o'clock on the 16th.
Okay. And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And Do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
And
Any redirect?
Yes, Your Honor.
is this the only school I've heard of that has been sued? And an individual?
You've indicated on cross-examination that your son, NJ, was not in Miss Werner's classroom. What was his homeroom?
His homeroom was Mrs. McAulifre's class.
And did he have occasion to interact with other students from other classes?
Yeah, in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about contact he had had with another student?
Objection, relevance, and hearsay.
Okay, and I was gonna ask you, are you asking me to give the statement or just to?
I am going to attempt to establish possibly an excited utterance.
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you can repeat, Mr. T.
Relevance and hearsay.
Okay, so it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that.
So if you can lay a foundation, and to the witness, sir, when we ask you to pause, and we can make sure that the evidence is appropriate under the rules of evidence. You may proceed.
In the immediate aftermath of the event, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with that day?
Yes.
Okay. And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting and how he sounded?
He was scared, shaky, and nervous.
Yeah, because I thought most schools.
Did he relate to
had
you something
immunity,
that had
like
just happened earlier that day?
Correct.
Robb Elementary?
Judge, I think that is sufficient foundation as to hearsay.
I don't think the school that Ethan Crumbly went
Under the
to
excited
were
utterance.
sued. I don't think individuals have been sued.
Mr. Cumberland has not.
One of the parents of a student, a first, second grader.
How long before?
Right.
We're talking about the shooting that had occurred at 2 p.m.
A second grader's parent.
Didn't pick up his child until sometime later in the afternoon, presumably hours later. Then I don't.
So not even one of the students that was in the classroom. This isn't even one of the students in the classroom.
The excited utterance exception is
parent
extended when the declarant is a child, because courts have recognized in Virginia
and like his kid wasn't even
nature
in the
of being a
classroom.
child and
Wasn't even
brain
in the
development means that the heightened experience of an emergency extends quite some time.
This is going
There
beyond.
are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803 excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with firsthand knowledge at the time under circumstances negating deliberation.
I mean, this woman's getting sued by everybody.
To show the causes and breakup and how to decipher that. It has not been established that the declarant, which would be the witness's son, had firsthand knowledge at the time, as he was not in the affected classrooms, and there's been no evidence other than that being a student at school since it happened, as to how he would have gained firsthand knowledge through an appropriate way. So I'm going to sustain the eviction.
I'm going to request to voir dire the witness so that I can establish exactly that.
Okay, you're asking to just go out of the presence of the jury.
Yes, Your Honor.
All right. Ladies and gentlemen, if you kindly retire to the jury room.
Oh my God. This guy is the father of a second grader, was not even in the same classroom. What the? He wasn't even on the playground. What are we doing?
Okay, parties may have a seat. Into the witness, you're still under oath. We're going to have some additional questions for you. But one more will work to the door.
This is.
You may proceed.
In that moment where you were just describing his demeanor, tell us what MJ told you.
That my son sits on the last seat because they don't have any doors in their classroom. So his seat, he could hear the pop. When he heard the pop, the teacher, they heard over the walkie-talkie that someone got shot. And they got everybody scrambled into the outside of the classroom, which was there in the direct line of supposedly their safe zone, which is outside of their classrooms.
Okay, let me ask you this question. Did MJ say all of that to you in that moment?
Yes.
Okay. And so if I understand your testimony correctly, is it that he heard the gunshot and he was in a classroom that had no door?
Yes.
Okay.
He heard a pop, I believe.
A pop.
Yes.
And then he had to evacuate with the school, basically.
He had to evacuate his classroom in the danger zone.
Okay.
Say that you're saying in or and the
In
danger zone?
in the danger zone because his class has no door. So the zone of where they have to go out is outside of their classroom in that same hallway.
Okay, and he used the word danger zone.
My son?
Yes.
No.
Okay, I think
Dude, you need to be specific.
In your verbatim statement.
He was in his the safe room. He went to the safe room.
Okay.
Okay, and Mr. Rogers, you were stating something you want to say something?
I was going to address his characterization of danger zone at the court.
Continue with your vote.
Judge, I'm not going to seek to admit the statement. We need to bring the jury back in. Thank you, Mr. Garcia.
Okay, so again,
So you keep your seats this time, not 20.
all of these parents, so not only did the teacher who was shot sue this principal and she's suing the school system, but all these parents, I did not know this, all the parents and the other teachers are suing her for money and damages. And she's being charged with 8 felony counts. My mind is blown. Where is the responsibility being put on this child's mother? I am flabbergasted.
Thank you very much. And normally they stand, I told them that they just stood, they didn't have to. So
I don't know if I could, like,
you may finish with your question.
her life is ruined. I don't know if I could live.
Mr. Garcia, had you personally ever been inside Rich Neck Elementary School?
Yes.
Had you personally ever gone to your son's classroom? And did your son's classroom have a door?
No.
All right, thank you. I don't have anything further.
That would be tough, man. That would be so hard. That's a lot.
No questions. Okay, all right. And the status for this witness?
I would ask that he be released unless there's an objection to it.
He can be released.
Okay, so what that means is you're releasing your obligation as a.
I mean, this is modern day. Yes, the teachers and the parents are suing this principal. So she's being sued multiple times, and she's being charged with 8 felony counts and looking at 40 years in prison. I don't know if I could even, like, that's a lot. I don't know if I would be able to function. And she's having to live with the fact that a teacher was shot on her watch. And she's being blamed for it. She's being blamed for it. After there were 4 other teachers before her that could have taken this. Yeah. Shba.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
This is like modern day witch trial.
Yes, sir.
I know the court has already ruled on Mrs. White's.
Okay, come on, and hold on one second. Come on in the witness stand and watch your step, and yes, you can move the chair and microphone. Yes,
The court's already ruled on Mrs. White's ability to be able to testify today. So doing my objection to any testimony she will give regarding how it's not relevant to what happened on January 6th regarding my client's conduct in the actual mission that occurred on that day. She can't testify to that because she didn't observe it. So I don't believe that she had anything of relevance to offer the fact finding data to decide.
I mean, what?
so noted, thank you. You may proceed, Mr. Chairman.
Good afternoon. Tell us your name.
Susan White.
Ms. White, how are you employed?
Right now I'm retired.
And on January 6th of 2023, how are you employed?
I was retired by then too.
Okay. And were you at Rich Neck Elementary School?
Yes, I was.
Why?
I was there for 34 years.
Okay.
And my last year was the year before
Right.
that happened.
And so I want to take you back to the year before that, which was that your final year before retirement?
It was.
Okay.
No, I'm sorry. I don't believe her answer was responsive to the question. There may have been a misunderstanding as to what was asked. So it definitely wasn't.
Okay, you can clear that up on cross-examination. You may proceed, Mr. Jenkins.
So during the course of your last year of teaching at Rich Neck, did you know a student who we're referring to as JT?
Yes, I did.
Okay, and as a reminder, we're not speaking the names of any students at all, only using initials. Whose class was JT in?
My class.
And what grade was that?
Kindergarten.
During the course of your time with JT, was there ever a discipline incident that you did report directly to Dr. Parker?
Yes.
I want you to start at the beginning of that incident that you eventually reported. So what was going on that day that began that?
He had gone up. This was during post-COVID, so we had to be careful with distances and with masks. And he'd gone up to the front of another child's desk with his chip and put his face over about 3 inches from the other child's face. And so I had to think, what am I going to do about this? Because just telling him no, or you need to get back to your seat or whatever, those weren't working with him. So I slid the chair slowly so that if he wanted to get up, he could get up. And if he didn't want to, he could stay seated. I was going to bring it to his desk. But then he pulled the legs away and dropped them. And so I brought it up a little bit further just so I could be right in front of the class. And I sat there and I kept on teaching.
Okay.
I was still talking with the students.
Let me pause you for a moment so we can kind of visualize the scene. So when he is in the face of another student, how is he? Is he sitting, standing, or doing something else?
He's sitting, leaning in toward him, staring him in the eyes.
Okay. And you testified that you pulled him away. Could you describe how you did that?
I slid the chair I was holding the back of the chair, and I slid it back. We had no carpets at that time because of COVID, so it was easy enough to do.
Yeah.
And so he hopped off and grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple feet further, and then I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair and I was talking to the class, and not about behavior, about the instruction we were doing. And he walked up behind me and put both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation was the assistant, the teacher's assistant that I shared with another teacher, happened to be in there at the time. She was in the back of the room. So she came up and pulled him off with me and took him out of the room. But until she pulled his arms off, I couldn't breathe.
What, if anything, happened with JT immediately after that? Does he remain in your room?
No, I wouldn't have had it. I would have left if he did. No, Mrs. Perger, my assistant, took him out of the room. But then sometime later in the day, and it got very blurry after that for me, so I can't tell you how long. One of our counselors and our security officer came and brought him back to my room.
So when you say, hold on, when you say brought him back, do you mean JT?
Yes.
Okay. So when
They
you
each had him, I'm sorry.
when you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand, and they were trying to get him to move into the room. And he was yelling, no, I don't want to go back in the classroom. And I looked at them, and I had his back to the doorway so I could talk to them without everyone in the classroom hearing. And I said, well, he's right. He does not belong back in the classroom. What he did was severe enough for me to contact the police and to press charges. And the security officer agreed with me.
Okay, so what happens with JT next?
Well, they told me they were bringing him back to me because no administrator was available to handle the situation.
Okay.
So I said that if he was going to stay in there, I was going to need to leave the room.
Did you in fact leave the room?
I did, but not because of that. I believe they took him back out again, but it's very fuzzy.
Okay.
What I know is by that point I was so shaky that Mrs. Perger, my assistant, said, go ahead and take a break. And I took my laptop and went to the lounge and got the incident referral form because I wasn't going to leave school without reporting that.
Okay, so hold on just a minute. You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think the discipline problem is dangerous enough or bad enough that you need to refer them officially, formally to the administrators.
And when you say the administrators, what titles do you mean?
Assistant principal and principal.
Okay. And who was the assistant principal at Rich Neck Elementary School at the time that this happened?
Dr. Parker.
And is Dr. Parker in the courtroom right now?
Yes.
Could you just point her out, please?
She's right there.
Okay. Will the record reflect that she's indicated defendant?
I was not, can you point her out again? I didn't see your name. Okay, so noted.
Thank you, Jim. So you've told us that you got an incident referral form, okay? And what did you do with it?
I filled it out and I typed up a whole description of everything that had happened that day because I had had some positive moments with him earlier. So I wanted those included too. So typed up the day And then I attached it to the referral form as the attachment and the explanation of the behavior. And then I went to the office and I saw that Dr. Goodman, the principal at the time, and Dr. Parker, they were in her office at the time.
And did you go into the office?
I went into the office. I told them everything that had happened.
Let me ask you this question. Did you have the incident referral form with you?
I had it in my hand.
Do you know who you handed it to or what you did with it?
I handed it to Dr. Goodman after I explained everything on it to both of them.
I understand. So after you explained everything that was on it, did, if you remember, did Dr. Parker or Principal Goodman react to that in any way? And if so, how?
Dr. Goodman did. When I was talking about the fact that if an attack is occurring, it should never be that no administrator is available to help with it unless there's a worse attack going somewhere at the same time.
Okay. Did Dr. Parker say anything or
No,
have it?
she was making eye contact. She was looking at me. She didn't say anything.
Okay.
Dr. Goodman said, sort of under his breath, prioritize. And I thought, well, yeah, that's what I wanted him to get from that. And then he told me to go to the nurse and have my neck checked out afterwards.
Okay.
Because Dr. Goodman.
That year, did JT ultimately return to your classroom or not?
He did.
Okay.
He returned the very next day. He walked in with his breakfast.
Okay.
And I immediately went to the teacher across from me and said, I need to go to the office so that she would watch both of the classes. Across from me and said, I need to go to the office so that she would watch both of the classes. And she saw who I had with me, and so she understood. And I just told him, he had his breakfast with him. I said, just bring it, come with me. And so we went to the office and I had him sit down in the waiting area for parents there. And I went into Dr. Parker's office, and I knew at that time that my assistant had to stay in a first grade class all day because the sub hadn't showed up. So I would not have another adult in the room. So what I told her is, I cannot be the only adult in the classroom if he's in that room. And so either he needs to be somewhere else or I'm gonna have to take a sick day and go home.
And was he relocated or what happened?
He must have been, because I went directly back to the classroom and continued teaching for the day. I didn't see him the rest of the day.
Okay. At some point later in the year, does he come back to your classroom?
No.
If there were, and if you remember, any other discipline incidents you saw yourself and you reported to Dr. Parker yourself, are there any such incidents?
With him?
With JT, that's right.
No, I don't believe so.
Thank you so much. I don't have any further questions for you. Please answer any questions of the defense counsel.
Do you have a moment?
Dang.
You all right?
Yeah, I'm okay. I thought he was asking me.
Oh, no, I just need a moment to confirm.
This little boy. Okay, the principal, both of them were wrong for not disciplining this child and him being able to come back to school. But hello, where is his mama? They didn't have a parent-teacher conference? Like, what the heck is going on at this school? They didn't call his mama right away? This is crazy.
Hello, Ms. White. You just testified that you reported JT's behavior or his presence in your classroom to Dr. Parker directly when he came back the next day, correct? Okay. And then when you told her that, after that, he never appeared in your classroom again, correct?
Right. And I had heard.
No, you don't tell me what you heard.
Okay.
So when you told her that action was taken and JT was removed from your classroom.
He went to another school.
Okay. All right. Regarding the incident referral that you mentioned, do you know whether Newport News Public Schools retain a copy of it?
I was told
They should. It goes in your permanent record.
Okay. And did you have to then supply it to someone else, your own copy that you maintained?
Yes.
No further questions.
And read the record.
Yes, Your Honor. Ms. White, I want to just direct your attention to the incident referral form. You've indicated there was a form. Was that the only piece of paper you submitted?
I submitted the referral form with the attached description of the day.
Okay.
So that I could get the full explanation of what happened, because this little place is not going to be enough.
Understood. And the a description of the day that you attached to the referral form, was it typewritten, handwritten, or something else?
Typewritten.
All right. If I showed it to you, would you recognize it?
Definitely.
May I approach the witness, Your Honor?
You may. You may.
Sure.
He always has the most irritated look on his face. Is like, we want to see it.
May I approach the witness, Your Honor?
You may.
What is it that I paid you?
You handed me the detailed description that I attached to the incident referral form. And
Oh, okay, and is what you're looking at now a true and accurate copy of the incident report as you wrote it?
yes,
Has anything been redacted from it?
well, yeah, but I did that myself for some that I gave to other people.
What was redacted? Is it a category? I don't know, I sort of words. Is it names?
Names.
Hold on 1 second, ma'am. What? Yes, sir.
Before she even answers that, objection, that document is here stated, it's an out-of-court statement, it's written, being offered for its truth of what happened on that day. She's testified as to what occurred. She's testified that she produced this incident report, but as far as the contents of that incident report, I'm objecting to it as hearsay.
The objection is premature. I haven't offered any evidence yet.
Agreed, premature, not yet right. You may proceed.
The redactions that appear are the redactions that you did.
The names, yes. I don't know what I had at the top.
Okay. Are you sure that that is the incident referral that you submitted attached to the form?
It looks like it.
Okay, it either is or it isn't. Take your time to read it.
Yeah. I was gonna say I write a lot, but yeah.
So is it the incident referral?
Mm-hmm.
Is that yes?
Yes, it's the attachment that I attached to.
Thank you. Judge, I am moving that now into evidence as Commonwealth 6 as a past recollection recorded for one thing, and also as a prior consistent statement, because the defense was alleging that or suggesting that it didn't exist, essentially, in cross-exam.
Your Honor, there was no such insinuation that it didn't exist. So that's number one. It's still hearsay. It's duplicative of her testimony and all the previous objections that Mr. Rogers lodged. And it goes beyond, I'm sorry, it goes beyond my redirect as well. I mean, my cross-examination.
And also, how is this not bolstering? How is this permissible bolstering? She testified to what she recalled happened, I think it was a year before.
Yes.
So, I'm talking to the attorney.
I'm sorry.
She testified to what she believed happened to a year before. Why are we allowing in her written statement, her redacted written statements about that?
Because defense counsel asked whether she gave it to the schools and whether it still exists. And I'm establishing that it does.
Okay, so I guess you're interpreting that as an attempt to impeach. And so you're trying to rehabilitate?
If the objection is hearsay, there's an exception to that. If we want to talk about why it's relevant at this stage, yes, we can go to the relevance rules and find that a prior consistent statement does become relevant when on cross-examination, or does become admissible when on cross-examination, the witness has been challenged as to having a memory or forgetting.
I didn't take it that way, but
rule.
And so, and again, I understand that's where the impeachment can come in, but that's the missing link for me. So, saying it does not come in, and you may approach to retrieve the document.
Thank you, Judge.
I didn't take the defense asking her that way, but they are so catty.
Right, thank you. I don't have any further questions for you.
Anything further? Okay, and the status for this witness? May she be excused?
I'd ask that she be released unless, I'd ask she be released.
And no objection from defense. Okay, so that means thank you for your testimony today. You are released as a witness. You don't have to go back to that room. You do not have to stay in the courthouse. You are welcome to remain in the courtroom if you'd like. Okay, so watch your step in. Thank you very much. Next witness.
Commonwealth calls for Alonzo Rawls.
I didn't think the defense was saying that she didn't do an incident report. I just think man, the prosecutor is getting defensive.
Raise your right hand, sir. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Please take the witness stand, sir. Watch your step, and you can adjust the chair and microphone as you need. You may proceed.
Good afternoon. Would you please tell us your name? Mr. Rawls, just a quick reminder that we're not using the names of any children today in court. We'll use initials in place of that. Mr. Rawls, in January of 2023, how were you employed?
I was a school counselor.
Where?
At New Plymouth Public School in Richmond.
All right. And how long had you, as of the January 2022 or 2023, I'm sorry, how long had you been at RichNet?
It probably would have been, between that time, it would have been like a year and a half.
Okay.
Not quite 2 years.
And during the course of your time at RichNet, did you come to know a student who we'll refer to as JT?
Yes.
And in the course of your duties, did you receive an assignment related to JT?
Yes. In his second year at Richmond, I was assigned to kind of be like his set schedule.
How did that assignment come about, if you know?
I don't recall in its entirety. I do believe that originally, because he was having some issues, they were trying to put a plan in place to help him to adjust him to the school and be more productive. So I believe the administration came with a plan up, and they administration need to help him out with that plan.
Tell us how, if you could just describe for the jury how the one-on-one assignment worked. What did you do?
Well, in the morning when he got off the bus or was dropped off, I would proceed to have a morning session with him, kind of set goals and plans for him in the morning. He would then go to one of the, I believe it was one of the SPED teachers to kind of reiterate those plans. After that, he was working with Mrs. Kovac on some, I think it was like reading assignments. She was a reading specialist at that time. And then when that point, after her time was up, I would come back, retrieve him, and I would take him to the classroom. I would be with him in the classroom.
Okay. And did you ever speak to Dr. Ebony Parker regarding this assignment with JT?
From my recollection, I don't recall. I just remember this is what they were requesting of me.
Okay. Do you know of any behavior issues that JT exhibited?
Yeah, his first year there, he exhibited a variety of different behavioral issues where he was out of the classroom or taken out of the classroom for whatever case may be, but it varied from time to time.
Okay. Mr. Rawls, do you know what an SST is?
Yes.
Okay, what is that? Can you tell us?
Student support team. It was basically a process or a program to put in place to help to assist them in trying to once again be more productive in the school system.
And did the SST plan involve regular meetings?
Yes.
Did JT have an SST plan?
They were in the process of moving forward with SST because I believe they were trying to transition that SST into more like an IEP, which is like a more specialized support system for students, and it was called the SPED system.
Okay. And who all was involved in the SST process for JT?
I was currently at the time under Newport News Public Schools and policies. Counselors were one of the main people that ran the SST process. Administration would be involved when they were available and things of that nature, but it was more so put on responsibility of the counselors.
Okay.
To coordinate the SST meetings.
And so at those SST meetings, who would typically attend JT's SST meetings?
It would be either the principal, the AD, myself, or another counselor, a parent, and if they had any advocates that would willing to be part of the meeting. That's how the group of people would be.
Were parents and guardians of children invited to attend those as well?
Yes, of course, yes.
You've mentioned principal and AP. What's AP?
Oh, systems.
Thank you. And as of JT's SST, who was the principal at the time?
During the time, the principal.
I'm sorry, I put you on the spot.
I can't remember.
Okay, do you remember who the assistant principal was at that time?
Dr. Parker was the principal during the SST process in that second year, yes.
Okay. Did Dr. Parker sometimes attend the SST meetings, if you know?
I believe she may have attended some, yes.
Okay. Did there come a time when you decided you no longer wanted to, or maybe that you no longer thought it was useful to have that one-on-one assignment?
Yes, because.
Hold on just a moment.
Okay, what happened? I heard something. Object leading. Okay, response.
I'll rephrase the question.
Thank you.
Did you ever decide that you did not want to continue the one-on-one relationship with JT?
As a social counsel.
Okay, same objection? Response?
I asked, did you ever decide that you didn't want to continue the one-on-one relationship with JT? He's already established the foundation that he had the one-on-one assignment. And did you decide is a question he can answer yes or no? He did decide it or he didn't. I'm not suggesting which of those answers is the right one, so it's not leading.
Okay, I think the leading part is to just continue the relationship with JT. But I think the proper phrasing would be, did you decide whether or not to continue or discontinue a relationship with JT? So if you could ask that, or do you want me to just?
Go ahead, Judge, if you would like to ask the question.
Did you get the question?
Yes.
Okay, can you answer? Thank you, sir.
It wasn't really a decision of sorts, it was a request, as a school counselor at that time. I had many students that I had to serve, and, I felt like it took away my opportunity to service a lot of the other students within the building. So I had requested if I could be relieved of that duty, so I could also service the other students. Besides, I could still assist. I heard it needed to be done with JT, but I also want to be able to service the other students within the building as well.
Thank you. During the time that you were working one-on-one with JT, did you experience behavior issues or witness behavior issues?
Can you repeat the question?
During the time you were working with JT, did you experience or witness behavior issues?
When we were more one-to-one, it tapered off more. He still had concerns here and there, but he knew the relationship we had, me being his one-to-one, that I would be there to help to correct or redirect a lot of his behaviors.
And what were the behaviors that you observed of JT at any point that year?
Non-compliant, defiant behavior, refusal to do work, just acting out of sorts where he was following directions.
Would those issues ever be discussed at the SST meetings?
At times, yes.
Okay. I'd like to take you to January 6th of 2023. You remember that day?
Yes.
What is the first moment that you realize something might be up with JT?
Objection, leading, soon, that time,
I'll rephrase. On that day, did you ever notice anything unusual about JT?
On that day, I didn't even really witness him that day until later. That was in that evening of the afternoon of that day.
Okay. Did you eventually become aware of a crisis that occurred that day?
It was brought to my attention that after dealing with another student, that something had took place at recess where JT apparently told another student something.
So I understand it's hearsay. Let me walk through that with him. During the day on that day, did you have occasion to speak with any students?
Yes.
And were there any students who shared a concern related to JT?
Yes.
Now, without telling me what the student said, did you describe the student's demeanor, how they appeared at the moment they were telling you the information?
They were very emotional, very sad.
Okay. Again, without telling us what was said, were they referring to something they had just experienced or seen?
I wouldn't say they just experienced it, but they experienced it at an earlier time where they still holding on to whatever was stated.
Okay. And with that information, without telling me what was said, with that information, where did you go?
With that information, where I went is I went to Dr. Parker to address the allegations that I heard.
Okay. Did you ask Dr. Parker to take any action?
I didn't ask her to take any action. It was presented to me that some action was taken at a particular time with something else. And then I requested her if I could take some action.
Okay. And what action did you ask Dr. Parker to take?
I asked her if I could take action of trying to search or to check the person of JT.
And what did Dr. Parker say anything?
She responded by saying that at the time, because of the schedule he had, his parent or parental guides would be coming to get him so that we could hold off at that time.
Okay. The concern and the desire to search JT, did you share your concern without telling us what was said? Did you share your concern with anyone else?
Only person that's like concern, I shared my concern with is when I went back to speak to Mrs. Zorn after I spoke to Dr. Parker.
Okay. Mr. Rawls, at the time that you asked Dr. Parker for permission to search the person of JT, did you believe that you had the authority to do that without an administrator's approval?
You know, my previous experiences, you just can't, in my position, you just can't search a student without some type of permission.
Okay. And finally, Mr. Rawls, as you sit here today, do you wish you had done differently that day? Okay. Thank you. I don't have anything further.
So it sounds like the school was doing everything they could to accommodate this child with one-on-one counseling, one-on-one studies, one-on-one teachers. Like, obviously, they knew this child had issues, right? And he just even asked this counselor, do you wish you could have done something differently? So everybody was involved in this child's, like, issues or whatever. Everybody knew he had issues, and everybody was trying to accommodate his issues.
Good afternoon,
He was
Mr. Wells. How are you?
5 and 6 years old.
Good.
It's not like they didn't think they could help him.
So on January 6th of 2023, you were the school counselor at Rich Neck, is that correct? Okay. And so at some point, was it at the very beginning of the year, did you assume the responsibility of having the one-on-one contact with JT?
Not necessarily at the beginning of the year, no, sir.
Okay. But at some point, you began one-on-one contact with JT, is that correct? Okay. And how were your initial interactions with JT? Were they positive, or was it a challenge?
At times it could have been a challenge, but we built a rapport from the year before where it wasn't as difficult for myself.
Okay. And so over a period of time, his behaviors began to get better. Is that correct?
I would say yes.
Okay. And you were part of the SST team. Is that correct?
Yes.
Okay. And you function as a counselor as a part of that team?
Yes, counselor.
Okay. Would you say that you were in a pretty good position to assess how JT was doing on a given day?
I would say yes.
Okay. And would you say that you had more contact or less contact with JT than Mrs. Kovac, the reading specialist?
I would say we probably had
About the same amount of time? Okay. And at some point, you indicated that you requested less one-on-one time with JT.
Yes.
But it didn't sound like it was because he was doing better, but it's because you wanted to be able to help more students at the time. Is that correct?
Yeah, from my standpoint, point of view is to be more accessible to students.
Okay.
Okay, if you could speak up and tap that microphone, let me see if it's on. Okay, talk into it so that the reporter can get your words down. Thank you. So if you repeat your answer.
Oh. Can you repeat the question?
So you got to a point where you were spending less time with JT. The motivation for that was to be able to spend more time helping, I guess, more students,
yes.
More people than just JT. Is that correct?
Yes.
Okay. All right.
Go ahead and mechanical squeaking. Now we think it's a chair. So just,
Oh.
well, you know where it came
No,
from?
it wasn't a chair. It was a voice or something like that.
Well, do you know where it's coming from or feedback?
It seemed to be from my right.
Oh, okay. So again, there are other courtrooms and other lockups. We can't do anything about those noises. I'm sorry. Just ignore them. These things on the wall, these are sound panels. So we have as many as we can have, as you see, to absorb all the sound. So
I know, right? He just all laid back.
Thank you.
He ain't in
Mom.
my office, damn it. He's in court.
So my next question is, do you, when you began to have less contact with JT based on your request, did you think that was a good move for JT? Do you think that may have been detrimental to his progress?
I can't even really answer that.
Don't judge me, China.
Okay. But based on your position, you thought as far as resources, you needed to have contact with more students. Is that correct?
Yes.
Okay. Maybe it's that's what it is. That's what it is. So I'm the source of distraction. So after you decided to have less time with JT, did you notice any kind of degrade or in his behavior?
Not necessarily.
I do the same thing. I do the dishes.
I won't say replace me.
And I straighten up.
Describe that go around or that
Wipe
next
down the
plan.
counters. Act like I'm all tired. I'm like, whoa, that live stream wore me out.
And so you actually observed that next phase of.
I act like y'all are all
planning
demanding.
JT. Okay, and did that next phase seem to cause improvement with JT's behavior?
As far as I know, once again, once I was alleviated from that, I wasn't so hands-on, but I would say it seemed like he was kind of improving. Yes.
Okay, so were there less calls from a teacher or from an administrator for you to respond to JT due to bad behavior?
On my understanding, yes. There was less calls to me, yes.
Okay, all right. Now let's talk about January 6th. Did you have contact with JT on January 6th of 2023?
Later in the afternoon, yes.
Okay.
Not like direct contact. I observed him.
Okay. You said not direct contact, but you actually observed him. What? So as a result of hearing information, you decided to go and place your eyes on him. Is that correct?
Yes.
Okay. And when you placed your eyes on him, was he in the classroom or was that on the playground? Where was he at? In the hallway?
I placed my eyes on him, he was in the classroom.
Okay. And when you placed your eyes on him, did his behavior that you observed, did it cause you concern?
No.
Okay. Did he seem like it was JT, his normal behavior? Is that
Actually, it seemed abnormal behavior. He was way calmer than he normally was.
okay? So he appeared calm. How long did you observe him?
It was a few minutes. It was long.
Okay. And during that few minutes, JT was doing okay. Is that correct?
Yeah.
Okay. And is it safe to say that you may have had some concerns for JT's safety or anybody else's safety, and that's why you wanted to put your eyes on him? Is that correct?
Well, not at that time. At that time, like I said, it was that normal for that behavior would be that calm in that setting.
Okay.
But I didn't have any concerns of him.
Okay. So you put eyes on him and you were satisfied that JT was doing well that day. Is that correct?
Yeah.
Do you did you have contact with him directly or indirectly after that?
No, I did not.
Okay. So you did not observe any behavior of JT on that day that made you believe that JT presented a threat of danger or harm to any of the students. Is that correct?
That's correct.
Okay. And I believe through the questioning, it seemed like there may have been an indication that there was some additional feedback that you received. Is that correct?
Yes.
Okay, did that cause you to need to put your eyes on JT again?
The initial feedback that I received had me concerned about what was being said, and that's when I wanted to address it about the Parker and things of that nature. The only other time that I saw JT, and I don't even recall really seeing him, particularly is when I went back in that classroom. I don't remember actually seeing him at that time.
Okay. Okay, and do you remember the timing of that when you went back into the classroom?
Once again, it had to be between the hours of 12:45 to 1 something.
Okay.
But I don't recall the exact time.
At any time did you feel like that you needed to step in and pull JT out of the classroom?
Only time that I felt after hearing the feedback that I would receive, and when once again I was told to hold off on that.
Okay. Did you agree with that decision?
At the time, I felt like it was the decision that was made, and whether I agree with it or not, I was just there to be in support. When I came back to the classroom, I spoke to Ms. Zorner, I told her what was said, and I just told her that I would be there if she needed me.
Okay. When you left Ms. Warner, did you feel like you were leaving her in extreme danger, or the students in extreme danger?
No.
Okay. When you walked away from that class, you were at peace with JT's behavior, what was going on in the classroom. Is that correct?
Yeah.
Okay. Now, so when the actual incident occurred, did you immediately think that, oh no, JT has shot somebody?
No. When they went into lockdown, I thought it was a drill initially.
So you were shocked that the incident actually occurred. Is that correct?
That's correct.
Even with the earlier feedback that you received. Is that correct?
That's correct.
Okay. You did not think that you needed to take any action to prior to the incident to separate JT from the classroom. Is that correct?
That's correct.
Separate his classmates from him. Is that correct?
That's correct.
You didn't feel like you needed to call the police? Okay. All right. If you believe that there was a gun, do you understand that it was your responsibility to separate JT from the classroom?
Yeah, I mean, that was my responsibility.
Okay.
It was.
Okay, and it would also have been your responsibility to contact authorities. Is that correct?
Correct.
Okay. You had been involved in previous incidents when JT was removed from the classroom. Isn't that correct?
Yes.
Okay, just a couple days before that. Okay, you were involved in that incident.
Yes.
Is that correct? Okay. You removed him from the classroom?
Yes.
The incident wasn't something that caused danger of harm to his classmates. It's a cell phone was broken. Is that correct? And that resulted in him being taken
that's
to the
no
office.
big
Is that
deal.
correct?
Yeah, it's like,
Okay.
6-year-old throwing a
Okay.
cell phone.
So as a staff member, even on that day, you understood it was your responsibility, if you thought that there was a threat to the students, to remove the threat or the students from that danger. Is that correct?
Objection asked and answered.
Yeah, that's fine. Ronna, can I have a moment?
Yes, ma'am.
I mean, but it does sound like that the school was making every effort to accommodate this 6-year-old and his attitude problem and his learning style. So it does sound like Mrs. Warner and JT did not like each other. Just saying. And whatever Mrs. Warner did to piss JT off.
Thank you. Any brief direct?
Briefly, yes, Judge.
Yes, sir.
Just so that I understand the timeline of events, you testified on cross that you went and put your eyes on JT. Do you know if that was before or after you spoke with the student and it caused you to go to the assistant principal?
No,
It's before, okay. Do you know roughly how long before you spoke with that student? Okay. Would it have been more than 2 hours?
It was earlier that day.
Okay. And what were the initials of the student that you spoke to?
I don't remember the first initials are.
Okay, thank you. I don't have any further questions, Judge.
Anything further from the defense for this witness?
Just a moment, Your Honor.
Hello, Mr. Ross. You just mentioned speaking with a student with the first initial of R. Did you ever
prosecutors
tell Dr. Parker what R has said to you?
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you did? Okay. Would you be surprised if you did not do that?
I wouldn't be surprised.
Okay. No further questions.
Every time a different attorney comes up on the defense side, the prosecutor just is like,
Judge, based on that, I'm going to need a couple of minutes
Okay.
before redirect, I guess.
All right. So we'll take this is a good time for stretch break and after lunch restroom break. So it's 3:25. Let's come back at 3:35.
he's like,
We're still in open. And retire to the witness room, and we'll bring you back out. And we'll have the jurors go back to the.
all right, I don't know what the heck is happening. Yeah. So, God, this guy's on the stand way longer than he needs to be. Everybody's on the stand way longer than they need to be. Every time the defense swaps out attorneys, the prosecutor's face, I can just imagine, because he's already said something about that. He's already said, I object to this swapping out of attorneys for the defense side. Why can't they just stick to like one attorney? But the judge already said it was okay. They could do that. But the prosecutor's objection is on the same witness. He understands, like we've seen them do that, swap out attorneys with a different witness, but not get up and ask questions with the same witness, two different attorneys. That's a lot. That's crazy. I have not seen that happen. But the prosecutor is just like fed up. Both of these attorneys, I just feel bad for this principal. I think she has gone through a lot. I think she's going through a lot. She has more civil cases against her. She'll never be able to pay the money if she gets found held more responsible with the parents and the teachers that are still suing her. I just think it's crazy. Also, if they're trying to use past incidents against her, trying to say that, this child has a history of misbehavior. What was she supposed to do? Predict that in the next year, this kid was going to, bring a weapon to school and do what he did. Also, you can tell from the incident when he was a kindergartner, that teacher told the principal, and the principal basically kind of brushed it off, obviously, because they let the kid come back to school the next day with no consequences or repercussions. So this kid didn't have anything done to him. And I just feel like, again, that falls on, but then again, we don't know what his mama's doing at home. We don't know what kind of discipline this kid gets at home. We don't know. We don't know. I mean, we don't know if he's getting his butt beat at home, and the kid is like this for some reason. So I just think it's sad. I think it's really, really sad. But I just feel like this principal, she worked hard for if it'd be, I mean, I think it's harder because she's not like a straight up like she didn't pull the trigger. She's not a evil person. There's no malice to her. It wasn't like, she's just a regular person. She probably worked hard, got her education. She's a doctor. She's an educator. It takes a special person to go into education, It's like nurses. And she's in administration. And I can tell you, like I said, my friend, she's an administrator. When she has to be on the testing side, oh my God, I know more about testing than any human who's not in the administration world or school world should know, because I have, listened to her talk about it, and it is a nightmare. It is a complete and utter nightmare what they have to go through. And testing is non-frickin' stop. I did not realize that these kids are always frickin' testing. And the administrators that have to be in charge of it are working around the clock. And also, I did not know until my friend, but administrators, they work all year long. They don't get a day off. They work all year, and they work from 6 in the morning until 7, 8 o'clock at night. And they have to be at every football game, every basketball game, every Upward Bound, every, they don't ever stop working. And then on the weekends, you think they get a weekend off? No, they don't get weekends off. They have to actually request those off. It's crazy. So, this is not cool. I feel like this is really not cool. So for her to be getting this much put on her, and then I just feel like, and then I just don't understand how come the school, I've just seen so many times where schools have been told that they have immunity, like Robb Elementary in Laredo here in Texas. They made that whole special about the lack of response time, the delayed response time on the police side of things when that school got, banged, and all those kids, all that happened. But if you go back and you look from all the mistakes on the school's part, there was a lot of issues on the school's part that are now hindsight 2020, backseat driver, whatever. You can look back and say, oh, well, they were propping the door open. They were using the lot. They were allowing people to keep the fence open so that they could use the door and bring in food and use carts and this and that and the other. And the teachers were using side entrances and all this kind of stuff. But they're not holding those teachers and the school accountable for that kind of stuff. They're only using the response of the cops and stuff. They're saying that they were very delayed. And yes, they were very delayed, but there were actually in the beginning, at that initial response, they were responding to a car accident in the beginning. And there were only 3 officers. They weren't responding to a active bang bang. They were responding to a car accident. And the first 3 officers that were responding, they didn't have gear. They didn't have anything. It was just the 3 of them. And actually it was 1 at first. And he's supposed to go in, and I don't know. It was kind of, it was a toss up. Like I felt bad, but they wanted that 1 cop to take the fall for every incident that happened at Robb Elementary. And I didn't think that was fair. I thought, it's not fair for you to put it off on one police officer who responded to that call when you had it was a actual ton of things that failed that school and those kids. It wasn't the one officer that responded to the call who was responding to an accident. He didn't know he was responding to an active bang bang. And if you listen to dispatch, it's all about how the communication was given. There was a failure on the communication. There was a failure on, it was a lot of fails, lots and lots of fails. But that school's not being sued. Those teachers aren't being sued. So it wasn't him, it was the chief. Now, technically it was the chief, that wouldn't let them go in. Yes, that was Robb Elementary. But the cop that they put on trial for it wasn't his fault. The chief, their radios didn't work inside the building. There was so many things that went wrong that day. But the cop that they put on trial was like the first cop to respond to the scene. That's the one they chose to put on trial to take the fall for everyone's mistakes. And he was found not guilty, rightfully so, because because he was the first one on the scene. I cannot believe they were trying to make him take the fall for everyone. And no one was taking responsibility. No one. Even the chief, they're like, well, what about the chief? And the chief was like, oh, I wasn't in charge. It wouldn't be me. And it's just like, well, who the hell's in charge? So because no one would say they were in charge, no one would take responsibility for why there was no one giving direction on who should go in, who shouldn't go in, who, it was a hot mess. It was a hot mess. Watching the videos of that day is disgusting. It's pretty sick. And it's all because no one particular person was in charge. And their radios didn't work. They were all standing out in the hallway. It was a nightmare. It was bad. But they tried to make the first responding officer be the one to take the fall for all of their poor decision making from the whole incident. It was a long time of non-responsiveness. That guy went in that school and did all the things he did. Yeah, it was a failure from the beginning. But it wasn't the first officer's response fault. He responded, but he didn't know where to go. He got there, he thought he was responding to a car accident. When he got there, he was given wrong information from the beginning. From dispatch, from the teacher we first encountered. She was like, he went that way. So it was a terrible thing.
All right, sir, if you resume the witness stand, and the sheriff, we can bring the jurors back up. Yes, ma'am. Yes, you need to come and connect audio. Please come on up. Okay. Thank you.
I got this
one. Okay, we got that one. What about the other one? He said this one. Okay. Yeah,
like I said, but none of those schools and teachers are being held accountable for their roles in lack of safety. The school, some of those classrooms, the doors did not open. They couldn't get the doors open.
Please rise for the jury.
They had been putting work orders in for those doors for a long time. If they had been able to open those doors, They could have saved some of those children. But no, they're not in trouble for that.
14 jurors in the court.
You all may have a seat, thank you. You may resume your.
Instead, they were just sitting up.
I'm sure, redirect.
This is redirect. Yes, be quick. Mr. Rawls, thank you. I believe you indicated to the defense counsel that you didn't remember what you had told or whether you told Dr. Parker about the incident at the time you asked for permission to search the backpack. Is it true that you don't remember that? Sure. Understandable. Did you give a statement to police in this case?
Yes.
And if I were able to provide you with a transcript of that, might it refresh your memory about what you said to Dr. Barker? Okay, may I approach, Judge?
Yes, and you responded yes, correct? Okay, he nodded his head, I just wanted to make sure it was recorded. Yes, you may
Be
approach.
careful, China.
I'm just going to give you this document to take a look and read there. We're at the pink post-it note, and after you're done reading, look up and I'll ask you a question. Hold on, don't read it. Yeah, sorry. Read it to your. Just read it silently, and then I'll ask you a question about it. Sorry. And does that refresh your memory about what you said to Dr. Parker regarding the incident?
To an extent, yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. At this point, he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
I'll do it. May I approach?
You just like him too.
I want this done properly. Yes, Your Honor.
Yes, may I approach?
You may approach.
Thank you.
And ultimately, the legal principle is you can't read from that statement. You can refresh your memory, but you need to testify from your memory. Okay.
Based on now that's refreshed, if he has an independent recollection.
Well, he said to an extent, so
Already did.
we'll flush it out, and we'll give you the opportunity to cross. Go proceed, Mr. Jenkins.
Having refreshed your recollection, do you remember what you said to Dr. Parker prior to asking to search the backpack?
When I spoke to Dr. Parker, it was already relayed to me that a book bag was searched from JT and then nothing was found in the book bag.
Do you remember if you confirmed with Dr. Parker that you and she knew what you were talking about? Or who?
I know enough that we confirmed that we thought something may have been in the backpack, yes.
Okay, thank you. I don't have anything further.
And Mr. Rawls, and from what you just recounted, nothing was in the backpack, correct? It had been searched and nothing was there, correct? Okay. And at that point, you did not believe there was any credible threat, correct?
Objection asked and answered on recross.
No, I'll withdraw the question, Your Honor.
All right, thank you. All right, anything further for this witness?
No, Your Honor.
All right, and the status for Mr. Rawls, may he be excused of this, need to remain.
I'd ask, oh, I'm sorry.
No, I'll follow you.
I'd ask that he be released.
Oh, no, we're going to ask that he be removed.
So we're going to ask that he be constructed. I agree to that. We'll ask that he be constructively sequestered, remain available for recall.
Are you, is that suitable to the defense?
Yes, sure.
Okay, and do you all have his phone number?
No, come on, Captain.
Absolutely, I do be happy to facilitate that happening.
Okay, so Mr. Rawls, what that means is you are still a witness. You still have the ability to recall. So do not discuss this case, do not discuss your testimony, but you do not have to stay in the courthouse, you do not have to stay in the witness room. You can leave or go about your daily business. You will either get a phone call, one, to come back to the courtroom, or two, that the trial is over and that you are no longer a sequestered witness. All right, any questions, sir? All right, thank you, you may step down. Next witness.
Megan DeLeon.
So this is supposed to be done supposedly tomorrow.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you, ma'am. You walk around, please, to the witness stand, watch your step. The chair and microphone are adjustable. All right, you may proceed.
Good afternoon. Would you please tell us your name?
Megan Delion?
Ms. DeLeon, do you have a daughter?
I do.
I want to just caution you, and I know we've discussed this, but during the course of this trial, we're not using any children's names, only using initials or referring to your daughter if you prefer. Back in January of 2023, was your daughter attending school?
Yes.
Where?
Richneck Elementary.
Is that here in Newport News?
Yes.
And what are your daughter's initials?
SD.
On January 6th of 2023, did you become aware of an incident that caused you to go to the school early?
Yes.
And when you got to the school, did you immediately see SD, your daughter? Do you eventually see her that day?
Yes, when they bring her out to me.
Okay. When you first see her, describe, without telling me anything she said, just describe her demeanor, how she appeared to you and how she interacted with you.
Initially, she just seemed happy to see me, her dad. It was later on in the evening when she kind of showed different behaviors.
By different behaviors, you mean different than prior to the events of January 3rd? Describe what behaviors you observed.
Just that evening, it was a very hectic day, so we just ordered a pizza in and just tried to put some show on to kind of, but the doorbell rang just for pizza and she just got very scared, jumped from her seat, the sound of the doorbell, and other sounds like that for many months to come just scared her.
What kinds of sounds would scare her?
Slamming of the door, I know, just loud bangs. She described the sound as a ladder falling when the gun went off. So loud sounds have startled her.
No, I'm going to object to her statement. Sounded like a ladder when the gun went off. Sounds like she's testifying as sickness that Stephen had stated. If that's what she has done, I'm objecting to the
If the request is to strike sounds like a ladder when the gun went off, I agree to that.
Okay, so struck, don't consider that, please. Next question.
So what other behavioral changes, if any, related to SD did you notice in the immediate days and weeks?
Not understanding why this happened. She loved her teacher. The teacher was kind, and she just understand why anyone wanted her
And who was her teacher, if you know?
this morning.
So was Ms. Werner's classroom her homeroom?
Yes.
Okay. As a result of what you observed with SD, did you seek help for her of some kind?
Yes. We went to just regular counseling through our insurance, and then also spiritual counseling through my church.
And how long did that go on for?
6 months.
That's from an objection.
These are the injuries that the neglect caused, the trauma to the children, and I believe that that is relevant.
So I'll allow it, but do you have additional questions down this line, or do you have additional questions in this line of questioning?
Only to elicit any additional different things that she noticed in her daughter. That's it.
I'll allow it, you may proceed.
Okay. We're from January 3rd to present. Any additional things you've noticed in your daughter that were not present prior to the January 3rd incident?
She's very, she doesn't want to talk about it. She keeps everything close hold. She holds in a lot of feelings and emotions. Recently, she went back to counseling because it's the time they said to start doing. They get to give her some time and re-engage with the counselor, and they said that she has depression, anxiety, and one other thing where she's always on alert.
All right. Thank you. I don't have any more questions for you, but thank you.
Good afternoon, Ms. DeLeon. You were never inside of Rich Neck Elementary School on January 6, 2023, correct?
In the building? No.
Okay. And you did not encounter your daughter in the building, correct?
Right out front. No, right out to me.
Okay. You filed a civil lawsuit arising from the events of January 6, 2023, correct?
Yes.
In this courthouse, correct?
In this courthouse, well, through Newport News, yes.
Okay.
What do you mean by that?
There's a pending lawsuit in Newport News Circuit Court, correct?
Yes.
Okay. And you've named Dr. Parker as a defendant in that case?
Well, I prefer not to talk about my opinions of the case.
Well,
It's more of a
I'm going to object, Judge, and ask that we not talk about a child's civil matter on TV, that we have not continue the broadcast while she's speaking about the civil suit that is her child's, really, not hers.
The court's ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the questioning party has the right to cross-examine about interest in the case. And if you just ask who the named parties, not what your opinion is. And I think you said I prefer not to share my opinion on it. So non-responsive as well. Repeat your question, Mr. T.
thank you, Your Honor. In that civil lawsuit, you have named Dr. Parker as a defendant, correct?
yes, please.
Okay. And you are seeking money damages from the defendants in that case, correct?
I'm more seeking justice for my daughter and what she went through.
And you are seeking money damages from the defendants in that case, correct?
Yes, there is settlement and discussion with that, yes.
Yes, but the loss, I know there are settlement discussions, I'm sure there are. But in terms of what you're asking for in that lawsuit is money, correct?
Yes.
Okay. And you believe that a criminal conviction of Dr. Parker would help in that case, correct?
I don't have any opinion about that or anything to say about that.
Okay. After January 6th, you requested that your daughter be transferred to a different school, correct?
Yes,
And that request was refused by Newport News Public Schools, correct?
it was.
Okay. No further questions.
Thank you. Anything further from the Commonwealth?
No, Your Honor.
And the status of this witness?
We'll ask that she be released. And we're also calling Nicholas DeLeon.
Any objection from defense to this witness being released?
No, Your Honor.
Thank you, ma'am, for your testimony. You are released as a witness. You are welcome to remain in the courtroom, or you may leave the building. Thank you. And the next witness's name again, I'm sorry.
Nicholas DeLeon.
Okay, Mr. DeLeon, please.
Your Honor, I'm going to object to the testimony of the next witness because I believe it's cumulative. I don't think that he will be able to testify to anything other than his
I don't know who they are, so, okay, tell me why it's cumulative.
Husband and wife.
Mother and father of the child.
Okay, it's just one witness, I'll allow, I mean, are you bringing out 5 relatives for the same child?
Absolutely not, Your
Okay,
Honor, absolutely
you
not.
can come out
This is it.
overruled. Mr. De Leon, please.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes. Sir, please take the witness stand, watch your step, chair and microphone are adjustable. You may proceed.
Good afternoon, sir. Would you please tell us your name?
Nicholas De Leon.
Mr. De Leon, just a reminder that we're not using the names of any children at all, including your own. But do you have a daughter?
I do.
And what are her initials?
SD.
And where did SD attend school?
Richmond Elementary.
Okay. And are, as of January 3rd, 2023, were you, let me ask the question like this. Who is SD's mom?
Megan De Leon.
Thank you. Between the time of January 6, 2023, before and after, were there any changes that you noticed in your daughter SD after that hadn't been there before?
Yes.
Could you just describe what you personally noticed or observed, but not anything that she said to you?
I noticed that she was anxious, depressed, very not like herself, as in being quiet, distant, couldn't sleep.
How long did that persist?
Quite some time.
Okay.
Months.
Okay. Did you and her mom seek any sort of treatment for her?
Yes, counseling and sort of counseling.
Has it helped?
I think it's hard to say at this point. She's still going through counseling. It's been up and down, I think, with her.
All right. And just to confirm, whose class was SD in?
Wonders.
And was that at Rich Neck Elementary?
It was.
All right. Thank you. I don't have any other questions for you. Please answer any from defense counsel.
Good afternoon, Mr. De Leon. All right. You mentioned your daughter SD. You don't have any knowledge of whether SD was in the classroom when Ms. Werner was shot, do you?
I was not there in person, but that is her classroom.
I understand. But you don't have any idea whether she was actually in the classroom, correct?
From what I understand, that she was in the classroom.
And what are you basing your understanding? Is that from somebody told you?
Again, I was not there.
Okay.
I can't verify that. But
So you can't verify that. I'm not asking you to tell me what you were told. That's hearsay. Okay. Now, you are aware that your wife, or I don't know the status of your relationship, but Megan De Leon has filed a lawsuit on behalf of your daughter in this courtroom, correct? I mean, this courthouse, correct?
Yes.
Okay. And that you're aware that Dr. Parker is a named defendant in that lawsuit, correct?
Correct.
Okay. And you're aware that money damages from Dr. Parker are being sought in that lawsuit, correct?
Correct.
Okay. And so you have a financial interest in a criminal conviction of Dr. Parker, correct?
I don't. It's on behalf of my daughter.
Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today, that's a separate case.
Just answer my
That's a
question.
separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. He said no.
No, it has not been asked and answered, Your Honor. I asked a different question.
Well, it's a different question, and I think you already answered it. Are you asking his answer to be struck?
Yes, it's irrelevant and duplicate.
Overruled, and your answer was no, sir, if I heard you correctly.
Correct.
Thank you.
No further.
Questions?
No further questions, Your Honor.
Any redirect?
No, Your Honor.
And status of this witness?
I would ask that he be released.
Any objection?
No objection.
Okay, thank you, sir. You excuse me to use it. As a witness, you may stay in the courtroom or leave, as you see fit. Next witness?
Commonwealth will call Tanisha Richardson.
So are they just going to keep putting parents on the stand?
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Yes.
And watch your step, and your chair, microphone, or justice.
Good afternoon. Would you please tell us your name?
Good afternoon. My name is Tanisha Richardson.
Ms. Richardson, do you have a child?
I do.
And in January of 2023, was your child in school?
Yes.
What are your child's initials?
KS.
All right. And just as a reminder, we're only using initials, not names today. Where was your KS in school?
He was in his classroom. He was in first grade in his swimmer's class at Richland Elementary.
All right. And did there come a time earlier than normal on January 6, 2023, when you had to go to the school, Rich Neck, to pick up KS?
Yes. I received notice that there was a community post on social media that there was a heavy police presence at the school.
Okay, let me stop you there. You're okay. Just let me ask you questions and I'll walk you through it, okay? So after you saw what you saw online, did you go to the school?
I did.
Were you eventually reunited with KS?
Yes.
Could you describe, without telling us anything that he said, could you describe his demeanor, how he appeared to you when you first saw him?
He was very tired. He was cold. And he was ready to get home. He was just really exhausted from the day.
Yeah. Did you notice any changes in his behavior after January 6th of 2023 as opposed to before?
Yes.
I want you to just describe what you were able to notice as his parent that changed after January 6th, 2023.
Oh, sorry.
It's okay, I understand.
And the news is directed to Bill Lee, so it's not going to go out to the press. I just wanted to assure you, we will catch it.
Thank you. I'm sorry. Airway, stomach aches, headaches, school avoidance, just a general anxiousness, just extreme fear, as well as hypervigilance.
When you say school avoidance, can you kind of describe to me what that means?
He was literally afraid to return to school.
How long was he afraid to go to school?
I would say until at least the end of the school year of that year.
Did you seek a type of treatment for KS?
I did.
Okay. What did you seek?
He actually had a psychologist initially, and then he also attended CBT therapy with a counselor weekly.
And how long did that go on, and is it still going on?
I would say it lasted about 1.5 years to 2 years, and we stopped it since then because his therapist went to a new practice.
Okay. Do you think that it has helped KS?
It has helped.
Good. Thank you. I don't have anything further for you. Thanks.
So the point of these parents are just to.
Good afternoon, Ms. Richardson.
How many parents are we going to parade up to the stand?
You currently have a civil lawsuit pending in this courthouse, correct? Regarding the incidents of January 6, 2023?
Yes.
Okay. And you've also, in that lawsuit, you've named Dr. Parker as a defendant, correct?
Unfortunately, I'm not. I don't feel comfortable discussing the details of that in this arena.
Your Honor, I'm just going to renew my prior objection. I understand the court's rule on the issue.
So the court will overrule the objection. It's appropriate to be discussed. So if you could please answer the question. Repeat your question, Mr. T.
Thank you, Your Honor. In the lawsuit that you currently have filed in Newport News Circuit Court, you have named Dr. Ebony Parker as a defendant, correct?
Correct.
And in that lawsuit, you are suing Dr. Parker and the other defendants for money, correct?
Yes.
Okay. And you and several other parents share the same attorney, correct?
That's correct.
And you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit, don't you?
No.
Okay. Have you made any other demands of Dr. Parker or the other defendants?
No.
Okay. Do you know when that lawsuit is scheduled to go to trial?
No.
Okay. When was that lawsuit filed?
I believe it was February of 2023.
February 2023?
I don't know.
Okay. Okay. No further questions, John.
You may proceed.
Just a couple of more questions for you. As a result of the incident on January 6, 2023, and all of the things that your son has done, have you spent money?
Yes.
I'm going to object to go beyond cross-examination.
I think that's right on point with the cross-examination. He asked if she was seeking money in a lawsuit, and I think it's very fair for me to ask if she also spent money as a result of the incident.
I'll allow you. You may proceed.
Did you spend money as a result of what happened to your son?
Yes.
All right, thank you. I don't have anything further.
Anything further for this witness?
No, Your Honor, I ask that she be released.
Any objection to her being released?
No, Your Honor.
Thank you, ma'am. You are excused as a witness. You may stay in the courtroom or leave the building. Next witness.
The next witness will be Ramon Gonzalez. Your Honor, I anticipate having this witness plus one more.
Oh my gosh. These are just more parents. Come up and say,
swear affirm the testimony about
What the?
whole truth and nothing but the truth?
I do.
Please take the witness stand, watch your step, answer questions for counsel. Thank you.
What is
Good afternoon,
happening?
sir.
Good afternoon.
Would you please tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Thank you. And I would like to just a quick reminder that during this trial, we're not speaking the names of any children at all and only using initials. Do you have a child?
Yes, sir.
What are your child's initials?
GG.
And did your child attend school? Did GG attend school in January of 2023?
Yes, he did.
What grade was he in?
First grade
And where did he attend school?
at Rich Neck Elementary.
Do you know who his homeroom main teacher was?
Yes, I do.
Who was it?
Abigail Zorner.
All right.
Are you chewing
Did
gum?
there come a
He's
time
chewing
on
gum.
January 6, 2023, when you had to unexpectedly go to Gigi's school, Rich Neck?
Yes, I did.
And when you arrived at the school, did you immediately see Gigi?
No, I did not.
Okay, stay with me and let me walk you through it. Okay. So eventually, did you see Gigi at the school?
Eventually, yes.
And when you saw him, could you please just describe, without saying anything that he said, describe his demeanor, how he was acting, and how he appeared to you?
He walked out of the school with a look on his face like he had seen a ghost, pretty much. I was crying myself. He wasn't crying, but he was in shock, like complete, utter shock.
Okay.
I need him to spit that gum out.
And from that moment forward, did you notice any changes in behavior from Gigi as opposed to before January 6th?
Yes, at home he was a little bit snappier with his brother. Whenever they would argue, he would be a little bit more aggressive. Other things like he had to sleep with him every night because he just felt more comfortable. Bedwetting almost every night. Things like that.
And were all of those things new after January 6th?
That was new after that. Okay. He loved to sleep by himself before that.
And did your family seek some help and treatment for Gigi?
Yes, we did. Right after the incident, we went, I want to say 2 or 3 times. Mm-hmm. And he was very adamant that he didn't want to go because we wanted to keep his life as normal as possible after the incident. So wasn't trying to force it down his throat.
Okay. And has he, at any time between then and now, has he sought any treatment beyond that?
Not since then. No.
Okay. And how long did any concerning behaviors that you've described last?
It still lasts to this day. Getting better gradually, I think. But still, he has a lot of mood swings. And the whole big wedding thing happens. It's very rough.
Did your family incur any expenses as a result of this?
As far as with the
for Gigi, as a result of this, did you have some expenses?
No, with the therapy that was provided, so we didn't have any expenses as far as that.
Okay, thank you. I don't have anything else for you.
Thanks.
Is that haircut for religious reasons? I just have to ask. I'm just asking. And then please, why did you have to go?
Good afternoon, Mr. Gonzalez.
Good afternoon.
You weren't at Rich Neck Elementary School on January 6, 2023, correct?
I picked up my GG that day.
But you were not inside of the building, correct?
No.
You learned about the shooting after the fact,
Mm-hmm.
of course. Did the school contact you at the time of the shooting?
No. I had a friend of mine, a coworker, contacted me and told me about the shooting.
But did the school ever contact you?
Afterwards, yeah.
How long after?
I would say an hour and a half.
Okay. Your child was not in the classroom where the shooting occurred, correct?
Yes, he was.
Okay. And you're saying he was a student in that classroom?
He was a student in Ms. Werner's classroom.
Okay. And you filed a civil lawsuit in this case, stemming from the events of January 6, 2023?
I don't feel comfortable talking about that.
And Your Honor, I'd like to note my continuing objection.
Okay, so noted. Sir, you do need to answer the question, please.
Yes.
Okay. And you have named Dr. Parker as a defendant, correct?
Yes.
All right. You're seeking money damages from Dr. Parker in that case, correct?
Yes.
Okay. And a criminal conviction of Dr. Parker would be helpful to that lawsuit, wouldn't it?
I'm not sure about that.
Okay. No further questions, Your Honor.
No, Your Honor, I ask that he be released, please.
Any objection from defense?
No objection.
All right, thank you, sir, for your testimony. You may step down, and by release, you can leave the courtroom or stay in the courtroom, but you're no longer needed as a witness. Thank you.
And the Commonwealth will call Sarah Gonzalez.
Oh my gosh.
Again, we're going to object. This is a duplicative witness. That adds nothing to the case. This is the last other parent of the child.
This is another.
So noted, overruled. You can bring out the witness.
Oh.
And this is the last witness?
This is the last witness, Your Honor.
I'm not going to, I'm just trying to line up.
I understand. I understand. I will take a moment to double check that this is
Understood.
that we're
Understood.
into, but yes.
This is ridiculous.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I actually do feel bad for this woman.
With this hand, watch your step. Chair and microphone are adjustable. You may proceed.
Good afternoon. Would you please tell us your name?
Hi, Sarah Gonzalez.
Ms. Gonzalez, do you have a child?
Yes.
Remember that we're only using initials or referring to your child as my child. What are the initials of your child?
G.
And who is Gigi's father?
Ramon Gonzalez.
Okay. I want to take you to January 6th of 2023. On that afternoon, where were you when you first see Gigi?
After the incident, when I saw him.
When you first see him on January 6th, 2023.
At our home.
Okay. When you first see him at your home, is it still on January 6th?
Yes.
And do you know roughly what time it would be?
It was in the evening.
Okay. Could you just describe for me, without telling me anything he said, but could you describe his demeanor, how he appeared, and how he was acting toward you?
When my husband came home with him in the car, and he came out, he was like he had seen a ghost, kind of. He was white, and his eyes were very big, and he was just kind of, I've never seen that look before, but he was like he was in shock.
Okay. Were ongoing after that day, were there any issues with Gigi that you noticed that were different than prior to the January 6th?
Yes.
Describe those to us.
He couldn't sleep by himself anymore. He had to sleep with someone else, and it just is, to this day he still sleeps with his older brother. and just refuses to sleep by himself. And he, frequent bedwetting started occurring after that. And frequent bouts of losing his temper, and just becoming angry, things like that.
And for how long did those things last?
For a long time. It's improved, I would say, but it still occurs. It was very frequent after that for quite some time.
Are there any other major life adjustments that your family had to make as a result of what Gigi went through?
Just trying to internalize it and, move forward. And, it's the impact on my husband and myself. It was pretty significant and caused a lot of anxiety and,
Objection volumes, impact on
I agree, Judge. We won't go down that road.
Okay.
Yeah,
We won't
there's-
consider that just to the child. Next question.
I don't have any more questions. Thank you so much. Please answer any questions from defense counsel.
If I had known it would be this,
Good afternoon, Ms. Gonzalez.
like,
You have filed a civil lawsuit in this courthouse as well, regarding the events of January 6, 2023, correct?
I don't feel comfortable speaking on that as it's relevant to my son.
Okay, objection noted, and you need to answer. Repeat the question.
You have filed a civil lawsuit related to the events of
every
January 6,
single one of them said
2023
that.
in this
Well, you shouldn't
circuit
have
court,
filed a
correct?
lawsuit then.
And you have named Dr. Parker as a defendant in that matter, correct? And you're seeking money damages from Dr. Parker and the other defendants, correct?
Am I still liable to speak on this?
Yes, ma'am, you need to answer the question.
Yes.
Okay. In fact, you and several other parents are represented by the same attorney, right?
Objection, Judge, that is not who they are represented by in the civil suit. It's not in any way relevant.
Response.
I think it's relevant. We have a series of witnesses, all filing civil lawsuits, and represented by the same attorney. I think it's totally relevant to these proceedings.
And I object to counsel saying they're all represented by the same attorney. He's not testifying.
Correct, that's not evidence.
Well,
And I'm going to sustain the objection. Who their attorneys are, it is not relevant.
Okay.
But, that there's a lawsuit is relevant for cross-examination. Next
Okay.
question.
And a criminal conviction of Dr. Parker would help in that lawsuit, right? What was your answer? I'm sorry?
Yes.
Okay. So you have a financial interest in these proceedings, right? I'm sorry?
I imagine that's part of it, yes.
Okay. No further questions.
That's all for this witness, Judge, and I would ask that she be released.
Any objection? Okay, ma'am, so you are excused from being a witness. Thank you for your testimony. That means you can stay in the court or you may leave, and watch your step as you step in.
Judge, may I have just less than 1 minute?
Yes, sir.
To confirm.
Okay,
Just step down.
this family hasn't spent any money on their child's therapy. Their child has not been back to therapy since the incident happened. Yet they're in a lawsuit to try to get money from the defendant and the school, but they have not spent any money on their child.
Your Honor.
They're trying to claim damages.
Your Honor, we will have motions to strike, but I do want to take time with our co-counsel and the defendant to make sure that we have every base fully covered. So I'm going to ask the court to consider going on recess for the remainder of the day, and then we'll come back first thing tomorrow and make our motions and present any evidence on behalf of the defense.
Come on. In terms of proceeding in that chronological fashion. fashion your position?
I'll submit to the court.
Okay. All right, so to the jury, we take up the motion to strike outside the presence of the jury. It's 4:25 today, and they're asking to do so in the morning. So I will kindly ask you all to report back and would you like the jurors to report? What time is the council prepared to do motions to strike in the morning? 8:30 or 9? And I'll give that an hour and ask the jurors to report an hour after that.
Any time is fine for me.
Understood.
You're gonna have to be prepared for 9 o'clock tomorrow morning.
Say that start at 9?
Yes, 4 motions to strike, yes.
4 motions, and ask the jurors to report at 10.
Yes, ma'am.
Okay. All right, so, thank you again for day 3.
Okay, so we will be back. We will start at 10 when the jurors start because I have an appointment at 9, so I will not be able to listen to all these motions and strikes and all this kind of stuff. But we'll be back on at 10 in the morning.
And last, please, I will not be able, the court to provide lunch tomorrow. My assistant's off. And she's the one who, while we're here, actually goes to pick it up.
So pack your lunch.
Be prepared to go out to get food tomorrow. All right, thank you very much.
Okay.
Please rise for the jury. Make sure you go.
Rise for the jury. Okay, y'all. Thank you for joining today. I'll see you tomorrow at 10. And tomorrow, hopefully, this trial will be done. I don't know. We shall see. All right. See you in the morning. Thank you. Kamsahamnida.